come to order. It is Wednesday, April 8th, 2026, and we do have a quorum present. Our first item up today is Senator Hoffman, Senate File 1131. Senator Hoffman, your favorite committee besides your own?
Mr. Chair and members, yes, I remember here when it was National Cheese Puff Day, and I brought you guys some cheese puffs. This was 14 years ago. And actually, beyond 14 years ago, Mr. Chair, I was reminiscing with Senator, the good Senator Limmer from Maple Grove about the fact that this bill was in an omnibus bill in 1999 when Kevin Goodnow had it as a chair over in the other body, Mr. Chair. So this is the uniform statewide licensure system for massage therapy. We've been in front of you before. There's an A5 amendment that some lawyer named Joel Carlson and some other lawyers got in, and they didn't like a single word on it and changed it from submitting to in good faith. If you want to get a lawyer's definition of what in good faith means, I'd be more than happy to sit in the audience and let them have that conversation.
We're not going to go down that road, Senator Hoffman. But this comes to us from your own committee, so it's not the first committee stop. It's not an author's amendment.
Correct.
So why don't you tell us about the bill, and then we'll just ask Ms. Primo to focus us in on our pertinent sections as well.
Mr. Chairman,
Senator Limmer.
I just had a quick question to the author. What
Senator
treats did you bring us today? That'll be dependent on our decision.
Well, there is, Mr. Chair and Senator Limmer, there's some smoked meats up in my office. If you want to stop by and get one, you can sure do that. So. But I didn't bring anything here, Mr. Chair. I'm sorry. All
right. No coupons for massage therapy?
No, I don't even have that. But I do, Mr. Chair.
We could all use one.
We have Rachel Romanelli who's here, and I can just tell you real briefly that this massage therapy under Minnesota Statute 146A, what this does is this bill replaces Minnesota's current patchwork of 100 local ordinances with a single statewide framework that improves the public safety, supports the small businesses, and reflects those professional standards that are already in place today. Under your jurisdiction, Mr. Chair, we have sections 9, subdivision 2, section 10, 11, 12, subdivision 6, 13, 15, and section 16, subdivision 1. So I would like to just bring in Rachel Romanelli. She is the chair for the American Massage Therapy Association, the Minnesota chapter, if that would be okay.
So thank you. We'll listen to what Ms. Romanelli has to say, but I'm going to ask you if you want to spend a minute or two on the framework of the bill, that's it?
Yep.
And then otherwise, we're just going to confine our conversation on both sides of the table here.
You're good.
To our jurisdiction.
So,
and I think the plan is to lay this bill over. Is that correct, Senator Hoffman?
Yeah, Mr. Chair, that is my understanding is we're going to lay this one over, and then it'll get added into the licensing stuff somewhere along the line. So,
all right.
Yeah, you're good.
All right, Ms. Romanelli.
Thank you, Mr. Chair and members of the committee. My name is Rachel Romanelli, and I have been a licensed massage therapist for 29 years, licensed in Washington State, and I am nationally board certified as well. I hold a current massage establishment license, a business license in Minneapolis, and for the past 14 years, I have maintained a successful practice in Minneapolis in a clinical medical setting. I currently serve as the government relations chair for the American Massage Therapy Association Minnesota chapter. This is the current state of Minnesota massage therapy right now. 45 states in the District of Columbia have statewide regulation for massage therapy. Minnesota is one of the 3 that does not. This is along with Kansas and Wyoming. California and Vermont have voluntary license or registration. Minnesota has approximately 5,000 massage therapists practicing, and 300 to 400 new graduates enter the workforce each year from 14 Minnesota massage therapy education programs that meet national education standards. It is our workforce that defines us, and trained professionals providing care in clinics, hospitals, and communities across this state every day. Our current system does not reflect that workforce. There are 856 cities in Minnesota, and only about 108 regulate massage therapy, and each do so very differently. This means inconsistent education requirements, inconsistent fees, and inconsistent enforcement depending on where some practices are located. So the question is not whether standards exist, it's whether they are consistent, enforceable, and equitable. And right now, they're not. Minnesota has Chapter 146A, which was not designated to regulate a hands-on healthcare profession. It lacks entry standards, oversight, and enforcement tools. We have seen reports of sexual misconduct occurring in this unregulated space. And when a complaint of sexual misconduct or improper technique occurs, the Minnesota Department of Health, which is where 146A is under, has limited authority and no enforceable repercussions. Our state and local law enforcement lack the framework needed to act. And as a result, bad actors can move from city to city and continue operating underneath this patchwork system. Even recent efforts like House File 286 passed last year have fallen short because cities cannot access the federal background check systems needed to enforce it. What is in place currently is a system that appears to regulate but does not adequately protect the public. Educated, trained professionals face inconsistent city requirements while untrained individuals can still operate. This is not about creating a new profession. This profession already exists. It is about bringing our system up to the level of healthcare workforce we already have and protecting the public by providing regulation. It is time for Minnesota to act. I respectfully ask for your support of Senate File 1131. Thank you, and I'm available to answer any questions.
Thank you, Ms. Romanelli. I think what we're going to do now is let's walk through the bill, and then we'll take up the 85 amendment when we get to that portion of the bill. Which is Section 13, which is within our jurisdiction. I got some notes from you, Senator Hoffman, about those provisions, so let's just turn the members' attention to Section 9, Subdivision 2 on page 12 of the bill relating to prohibiting registration for persons with certain backgrounds. And we'll see if there are any questions from members of the committee or discussion relating to that provision, that subdivision 2. All right, we'll turn to Section 10. It's on page 13, relating grounds for disciplinary action. Any discussion from members of the committee on Section 10? Section 11 is on page 17 of the bill, relating to disciplinary actions. Any discussion or questions from members of the committee on that? Senator Holmstrom.
Thank you, Mr. Chair. Senator Hoffman, my understanding is that everything here is, you can choose to opt in, correct?
Senator Hoffman.
Mr. Chair and Senator Holmstrom, the answer is yes. That was, we dealt with that in HHS committee, so.
Okay, that's right. So with the
Senator
disciplinary, thank you, I apologize. I had too long of a break. Thank you, Mr. Chair.
We'll bring you back to standards. So don't worry.
So with the disciplinary actions, it seems like most of them are just, they can no longer be part of the program, but there is a civil penalty. I guess my question is, do you see that there's going to be a lot of actual people buying into this if they're opting into an opportunity for a massive fine?
Senator Hoffman.
Mr. Chair and members, yeah, the answer to that is yes. This is what the industry wants. They want they want this. They need this. So the answer is yes.
Senator Holmstrom.
Just a simple follow-up on that is, so my fear is that there is a path to where this starts as an opt-in, and then a couple years later we come back and it becomes mandatory. And a $10,000 fine is a significant fine for most of these are small businesses. It just feels like that's a massive penalty. Is there a reason it's so high, or is there any standard that sets that this is normal in this situation? I don't work in this field, so.
Senator Hoffman.
Mr. Chair and members, if you look at the language before that impose a civil penalty not exceeding, so the max, so the discretion of the ALJ or the whoever that's in front of it, that's the ceiling. It's not to exceed that $10,000. So, I mean, if you want some other language put in there, you know, that would do that. But I think that having a word that says not exceeding 10 gives that the discretion to the complaint receiver saying, all right, this is what we're going to do.
Senator Holmstrom.
Thank you, Mr. Chair. Yeah, I guess my fear is just that we might end up disincentivizing additional people from entering the field. I don't imagine it's high profit. So I would like to see that number be less. I don't know what number makes sense at the top of my head, but maybe there's a conversation to be had about this before it hits the floor. I'm not sure. Thank you.
Any further questions or discussion on Section 11 relating to disciplinary actions? It looks like, Senator Holmstrom, within that paragraph 6, there are some guidelines or guardrails, if you will, around to assist the decision maker in determining what the appropriate civil penalty would be in any given circumstance. So it's not just a flat not to exceed, but you should factor in the following considerations in fashioning that. So I assume a large provider would face a different economic threshold for penalty than a small provider would. All right, let's move to Section 12, Subdivision 6. Members, that is on page 21, relating to courts. Any discussion or questions from members of the committee? All right, Section 13. This is on page 21 relating to immunity, and this is where the A5 amendment is relevant. So, Senator Hoffman, do you want to describe the A5 amendment, or did you want someone else to describe that as well? What's your preference?
Mr. Chair, Joel Carlson is the person who worked on changing, inserting before submitting, inserting in good faith. I can have him explain that in his
Mr. Carlson, if you would come forward. Mr. Carlson, go ahead and introduce yourself and help us understand why the A5 amendment is being offered.
Thank you, Mr. Chair and members. Joel Carlson, I'm here on behalf of the Minnesota Association for Justice, and I appreciate the advocates for the bill sending it to us for a review. It has some good things in there relative to this practice, and including a practitioner's database and mandatory insurance. Those are all good consumer things. But the one thing that we noted that was in almost every single one of these reporting requirements is the obligation on the reporter to do so in good faith. It's made at a proper time, a proper place, and with a proper motive. And the only thing the A5 amendment does is add the good faith requirement to this, which was not in the verbiage. It protects the practitioner from a false or malicious complaint. So that's why we suggested adding it. And I did a word search, and good faith appears in Minnesota statute almost 800 times. And so now we'll be 801. So thank you, Mr. Chair.
Any questions or discussion from members of the committee on the proposed A5 amendment? Not seeing any. Senator Clark moves adoption of the A5 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion on Section 13 relating to immunity? So members, on section 14, this was not highlighted at first, but there is a reference to chapter 13 data on page 22, line 29. If anyone has any questions about that, now's a good time to ask. Then we go to section 15. Senator Limmer.
In reference, Mr. Chairman, to Chapter 13, is there a more specific clause that would be recognized? Or council might be able to give some insight? Or are we just talking about the classification of data?
Ms. Primo.
Mr. Chair and members, I'm assuming this reference is to civil investigative data, which is classified under section 13.39, I believe. If the committee wanted to, we could certainly make those changes to reference civil investigative data in section 13.39.
Ms. Primo, what would be standard legislative drafting practice on that question?
Mr. Chair and members, it's really somewhat of a choice. Even without a reference to Chapter 13, it is likely that this data would be covered by Section 13.39 because Chapter 13 sets up default presumptions. It is, if the intent is to make sure that the data is classified under a very specific provision, then, it's always better to reference that specific statute or that specific definition. It's really up to the members and the author. Either approach is likely fine.
Ms. Primo, are there other sections of Chapter 13 that would need to be referenced if we were to get if we were to get specific, or is just referencing point 39 sufficient, and then any other application of other parts of Chapter 13 to that would be covered?
Mr. Chair
Ms.
and
Primo.
members, yes, that would be the downside to making this very specific. And I am just taking a guess at this point about how this data would be collected and kept. So I think if the idea is to just make sure the default provisions under Chapter 13 apply, the way it is drafted is likely achieves that goal and doesn't unintentionally classify the records in a way that we're not necessarily getting the full picture of here.
So members, the plan is to lay the bill over, so I think what we'll do is just, I'm going to recommend we leave it as is and ask Ms. Primo to give a little more thought to this, and if there's any reason to get more specific, we can deal with that when the bill's back before us. Senator Limmer, follow up?
Yeah, real quick, Mr. Chair. Usually investigative data, let's say under certain provisions, let's say criminal investigation data is considered confidential until there's a finding, until there's a conviction, or until a prosecution fully establishes its path. You don't want to make any unnecessary accusations in public until there's more of a finding. So it's in the investigative process. I did hear the word civil investigative data, which is different than criminal, and we haven't talked about that in a long time in this committee, so we can pass it off to council and revisit it when the appropriate time. But it is important to make sure that you don't castigate someone in public until there is a finding that perhaps a prosecution should be in order.
Senator Kroon.
Thank you, Mr. Chair, and this could just be for council when doing this. I guess what I'm interested in is whether there's any other investigative data in Chapter 13 other than 1339, because what I would want to make sure is that 1339 subdivision 3 or some equivalent of that would apply regarding inactive investigative data, so when it would become public. So if this is the only course, then I don't think there's a problem, but just to make sure there's no other investigative data I'm not thinking of.
Any other discussion on that point?
Love it.
Not seeing any, will take us to section 15. That's on page 23 at the top. Disciplinary record on judicial review. Any discussion or questions from members of the committee on that one?
Mr. Chairman,
Senator Pappas.
I guess I just wanted some rationale why the record is sealed, except for the final decision. I don't know, is that usual or typical, or?
Senator Hoffman.
Mr. Chair, I think we're going to have Mr. Goodnow come up here, Ms. Romanelli. I do know that the administrative record is sealed. The decision is public, but some of the stuff alludes to which, by the way, Senator Pappas, I do love this committee. When those two start doing their little thing, it was just absolutely joyful to watch. There might be embedded in that 13.39 conversation about what's public, what isn't public. In this case, the decision of the commissioner is public, but the record of the administrative review is
Right.
not public, so.
Senator Pappas, did you want any further?
Well, I just don't know why the
Information.
full record wouldn't be public. That's why I'm
Mr. Goodnow
asking
here?
if it's usual.
Do you have anything to add, Mr. Goodnow? Nothing? Okay.
Okay.
Ms. Primo, anything to add on that point? Nothing?
Nobody seems to know why. All right. Well, it needs some work.
Mr. Chair. Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair. Maybe the question for council is whether or not this administrative review or disciplinary action would be considered a civil action under 1339 subdivision 2. If it is, then I think all of the concerns are taken care of. If it's something else, then maybe not.
Why don't we set that aside from Ms. Primo's review also for when we return to this bill? All right, let's turn to section 16, subdivision 1 on page 23, licensing authority, or license authority, effect on municipal ordinances. Any discussion or questions from members of the committee on this? Senator Pappas.
Mr. Chairman, Senator Hoffman, when you were in, I think you came from state and local government, is that correct? Oh, Health and Human Services. I'm just wondering, does this bill have to go to state and local government since it impacts municipalities? And I was just wondering if the cities have kind of weighed in on this. I understand what you said about a patchwork of regulation. Oh.
Senator Pappas, I'm informed the bill is already in state and local government's omnibus bill. They added it in policy deadline, so
I see.
that committee has had an opportunity to consider it.
Okay. All right, thank you.
Anything further on that, Senator Hoffman?
No, I just said Pierre is here from the League of Minnesota Cities if you needed that, but you just explained that piece of it, so we're good.
Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair. On the exceptions here in subdivision 2, it says a municipality can still require a business license and can still do require a criminal background check. What other regulations do municipalities currently require, other than those two, that would be streamlined into a state license? Could you give a couple of examples?
Senator Hoffman.
Mr. Chair and Senator Cronin, 108 different municipalities all approach this differently. It's really, that's why you see the word patchwork is there. And then if I could go back to Senator Pappas's piece of the same area you're talking about, when you have a complaint that is a victim of sexual inappropriate, the sealed record of the review is going to have some personal identifiable stuff in there, and so that piece of it needs to stay sealed. The decision does not need to stay sealed. In that case, if you want to get Pierre to come up and talk about what each city, but it's such a patchwork, it makes absolutely zero sense, Senator Cronin. It just absolutely makes zero sense.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I mean, I'm assuming certain municipalities require certain requirements in terms of how this business is conducted and requirements and all those sorts of things that you want to get under one umbrella statewide, but then a city can still do, require a license, can still do a background check, but just limit it to that. Is that kind of the general intent of what's going on here?
Senator Hoffman.
Yeah, Mr. Chair and Senator Kroon, correct.
Senator Pappas.
Mr. Chairman, as I read the language, they could still do a criminal, they can only do a criminal background check if the therapist is not registered. If they are registered, then they're not supposed to do a criminal background check. I'm assuming because that's already been done in the registration process.
All right, any further discussion on Senate File 1131 as amended before we lay it over? Ms. Primo.
Mr. Chair and members, just turning back to the issue related to civil investigative data and section 15 regarding the court sealing the administrative records, both provisions nearly identically are in the chapter that governs medical practice under Chapter 147. There it states the board shall maintain any records obtained pursuant to this section as investigative data pursuant to Chapter 13. And then it also includes the same provision related to the court sealing the administrative record. So I'm guessing these were provisions taken from these chapters or similar chapters that currently regulate various health professions. And as I read 13.39, the definition of the pending civil legal action also includes administrative proceedings. And I can't think of another section in Chapter 13 that would govern the investigative data that would be collected under this section. So I believe this provisions under 13.39 would apply to this sort of investigation.
I think Ms. Primo just saved herself some work after committee. Any further discussion on Senate File 1131 as amended? Not seeing any. I can see Senator Hoffman's endorphins are just flowing. He's having so much fun here. All right, Senate File 1131 is laid over. Thank you.
Mr. Chair and members, thank you. And I truly have to tell you how joyful it is to watch you and Warren Limmer have a conversation about stuff. So thank you.
The next stuff we're going to take up is Senate File 3861, Senator Mohamed. All right, members, this bill comes to us from Health and Human Services. And is the entire bill within our? Okay, so we're going to have Senator Mohamed, if you would just give us a very short sketch of the bill itself, and then Ms. Primo is going to identify the two sections that are within our jurisdiction. Or maybe you can, Ms. Primo, why don't you do that now so members can take a look if they wish ahead of time. Ms. Primo?
Mr. Chair and members, that would be on page 35. It's sections 26 and 27.
And members, for your information, also in your packet are two proposed amendments that appear to replace, at least the A6 amendment appears to completely replace sections 26 and, well, and delete section, to replace 26 and 27 with a new 26. So give that some review as we hear what the bill is about from Senator Mohamed.
Thank you, Mr. Chair. Appreciate you. I will start with presenting the elements of the bill and the parts that specifically touch this committee. Last fall, the Department of Human Services identified 14 types of services they called high-risk programs. That gives legislators an obvious assignment. If there are 14 high-risk programs, it's our job to cut the number 14 to 0, get rid of the phrase high risk, and protect the programs. And most importantly, prioritize the hundreds of thousands of Minnesotans they keep alive and well. This legislation would protect the integrity of delivering high-quality care from end to end, first before a provider ever enrolls a recipient, then again in real time as care is being delivered, and finally afterward with stronger compliance. Those larger pieces of the bill have been discussed in our Human Services and Health Committee. Before you today is one element regarding the release of information to the public. Around the same time the state identified those high-risk programs, the state also contracted with Optum and established a prepayment review process. Within the first 90 days of implementing the new auditing process, Optum provided an assessment of its initial findings, including reviews of vulnerabilities and potential solutions. That report was submitted to the Department of Human Services, and earlier this year, a heavily redacted version was released to the public. There has been a lot of pressure to release the Optum report in full to the general public as soon as possible. Many of us who are committed to protecting these programs from fraud believe that is a bad idea. The preliminary Optum report represents a point in time of new prepayment process. DHS and the legislature are working on solutions now, and releasing an unredacted report to the public now threatens that work. We wouldn't publish a report about which banks don't lock their vaults. The report is an assessment of weaknesses for us to fix, and that means it's also a roadmap of weaknesses for bad actors to exploit. Under the language in this bill, the full unredacted report would be made available to the legislators and staff who would be prohibited from sharing or publishing that information under penalty. This means our leaders at DHS and here at the legislature can utilize the findings and strengthen our systems without further risking taxpayer resources. I'm confident that this path makes the most sense, and you don't have to take my word for it. We know the difficulties in the lower chamber, and I will note that this language has already been passed overwhelmingly off of the floor of the House. With that, I will take questions and amendments, Mr. Chair.
Thank you, Senator Mohamed. The provisions within our jurisdiction are sections 26 and 27, so let's please focus our consideration of the bill on those sections. Any discussion relating to sections 26 or 27? Senator Holmstrom.
Thank you, Mr. Chair. I'd like to offer the A6 amendment.
Senator Hoffman offers the A6 amendment. Members, it is in your packet. Senator Mohamed, have you seen the A6 amendment?
I have.
Senator Holmstrom, would you please describe your amendment and the effect it would have on the bill?
Thank you, Mr. Chair. Yes. So the A6 amendment, well, right now, 6 and 27 matches the language of the provision that the House had passed. So it would make a clean passage. However, due to public concern about the nature of that bill not being open to the public and all legislators, I put forward this amendment out of an abundance of respect for the public and transparency. I think everybody is concerned about fraud. I think they all want to see this report and understand just what the failures were here in Minnesota. So that's why I put this forward. Thank you.
And Senator Holmstrom, what exactly would your amendment do?
Oh, my sincere apologies, Mr. Chair. So the amendment would simply put forward the original language that was offered to the House, which would release the Optum report unredacted to the public and to all legislators. So it would not just be a select few of people who receive it, but rather everybody, and it would still allow for the redaction of the private data that was in the report.
Senator Holmstrom, I'm a little bit confused about your description. Paragraph B of the A6 amendment requires the release of the entire report without redactions or edits, except for redactions requested by Optum to protect proprietary information, which I assume means Optum's proprietary business information. Doesn't say anything about private data on individuals. So I'm not seeing not consistent with the way you just described it. Can you help me understand that a little bit better?
Yeah, so it would be it would not allow the department to redact. They would be the original Optum report that did have redactions for those items, to my understanding.
For which item, Senator Holmstrom?
Private data of the businesses. Mr. Chair.
So, Senator Holmstrom.
So the original Optum report did come to the DHS with redactions. Those redactions would be legitimate. All pages of blacked out, every piece of text that the DHS had put forward would not be legitimate.
Senator Mohamed, what is your position on the A6 amendment?
Thank you, Mr. Chair, and Senator Holmstrom did come to my office before this, and I will state sort of what I said in my remarks, and I had also said it to my office. Part of why we accepted this language was we want a language out there. We want the report out there, but we want to make sure it doesn't create more loopholes for people to take advantage of our programs and create more fraud. Our job is to close the loopholes. I think that this is the right way to go about it. It is the most common sense. It gives legislators and the agency an opportunity for them to look at the report while also finding ways to close the systematic issues that we do have. Completely releasing the report as it is, the agency has spoken about it, that it would create more fraud, and I think that's something for us to be concerned about. So my position is I would ask members to not vote for it, and the language we have in the bill did pass in the House chamber overwhelmingly.
So I'm looking at the language in the bill itself, and it's got protections in there for the legislature in its oversight responsibilities to receive not public data as a part of the Optum reports, but then prohibits the distribution or publication of any of that not public data by the legislative oversight.
Correct.
So, Senator Holmstrom, is it your anticipation then that not public data would be released under your A6 amendment?
Again, Mr. Chair, that would just be the redactions from the DHS. Is what I believe that this is, that non-public data that's being referenced is the pages and pages of blacked out text. That's what the select few legislators would have access to under this current language. My language would say anything not redacted by Optum. The DHS redactions would be pulled off and viewable by the public.
So what happens if Optum does not redact not public data? Then they have to, DHS wouldn't have any ability to then stop the release of that not public data? Senator Holmstrom.
Thank you, Mr. Chair. DHS had an opportunity to be responsible about the Optum report, and they chose to redact nearly every single word. Their failure to be transparent is why we're even discussing this right now. So I don't trust DHS's management of this to begin with, which is why I brought forward the amendment.
Well, Senator Holmstrom, I'm still not clear, though. My question is, what if Optum has a report that, for whatever reason, mistake, oversight, not understanding, whatever, fails to redact not public data, and they give that report to DHS? Are you saying then that DHS would have to release that not public data that Optum failed to redact when they should have under the law? Senator Holmstrom.
Thank you, Mr. Chair. So Optum was given, to my understanding, Optum was given instructions on what to redact and what not to. If they failed in that endeavor, there may be a cause of action there. However, once again, it depends on whose definition of not public data. If you ask DHS, every single word in there is not public data. So I guess we're going to be arguing over definitions here, but Optum was supposed to redact the data, and if they didn't, then again, there may be a separate cause of action, but DHS clearly isn't the entity that we should be trusting right now.
So Senator Holmstrom, what we do in this committee is argue over definitions. That's what we pass or don't pass. So whatever is deemed to be not public data, you would rather have that released and let someone who's a victim of that publication of their not public data sue to try to undo the harm from that release, which we know can't be undone, rather than give DHS some discretion or any discretion to identify that not public data and prevent its release in the first place. Is that my understanding?
Thank you, Mr. Chair. I'm open to an amendment that describes specific data that we would want to be redacted. However, the problem and the reason that this conversation is happening is that you and I have no idea what the Optum report even looks like to know if they failed. Again, they're a government contractor. The government gave them a task to do, and they accepted the results of that. There was clear parameters in there for what should be redacted. If you want to add an amendment, I'm happy to work with council and offer an oral amendment to define that any financial data about a specific business that shouldn't be public can be redacted first. That's okay. My fear is when we have no definition, when we allow them to use their own discretion, we've already seen what we get, and it's a complete boondoggle of transparency. I'm not interested in moving forward with that. And I don't think most Minnesotans have that interest either.
Well, Senator Holmstrom, it's not up to me to try to fix your amendment if I think the amendment falls short. But not public data has a very specific definition. In fact, it's referenced in the original bill here as Section 13.02, Subdivision 8A. So if the Optum reports include that data, let me ask Ms. Primo, as a government contractor, Optum would have some obligations under Chapter 13 to comply with Chapter 13 just as if they were a government agency, right?
Mr. Chair and members, yes, that is correct.
And yet, and as part of the purpose of their report is to be able to give information to assist DHS in their responsibility under the law to try to prevent fraud and misuse of public dollars. So it may be if they share not public data with the overseeing government agency, that would not itself be a violation of Chapter 13, would it, Ms. Primo?
Mr. Chair and members, I think it might be helpful to look at the specific statute that governs this relationship between a private entity and a government entity. That's 13.05 subdivision 11, which states that the private person, when they enter into contract to perform that government function, must comply with Chapter 13 as if they are a government entity, and provide the specific notices and additional information as if they are a government entity as well.
So
But,
Ms.
oh,
Go
sorry,
ahead.
Mr. Chair, I'm just reading through this, but that requirement does not create a duty on the part of the private person to provide access to public data to the public if the public data is available through the government entity. So essentially, I'm assuming how this may work in practice is it's not Optum that themselves would be releasing any data. The request would likely still go through the government entity that is contracting with the private entity.
And Ms. Primo, what would Optum's obligation be with regard to the content of the report that is provided to the government entity? Can they include not public data in that report without violating Chapter 13?
Mr. Chair and members, some of this may be just, governed by the data sharing or the contract that they enter into. But Optum and the government entity that they contract with could share data with each other, because whatever the purpose for collecting that data is, that's governed by the need to reasonably access the data. So Optum would have an obligation to treat the data as private if there is an applicable provision that governs it under Chapter 13, and they would be subject to the Chapter 13 remedies if they released that. But they could provide private data that they collect, and they could exchange it with the government entity for purposes of fulfilling that contract. And I'm hoping that answers your question, but happy to try again.
Yeah, no, it does, Ms. Primo. So it seems to me that it's the government agency that ultimately has the authority and the responsibility to take any action to prevent the improper expenditure of funds or money going to the wrong places, or any enforcement action against recipients of these funds. So it seems to me that Optum is contracted to gather data, draw conclusions, make recommendations to DHS. The DHS has to be in a position to have access to that information in order to assess whether the report they've got from Optum is well-founded and the recommendations are well-founded, and whether to follow through on those recommendations with any enforcement actions. So Optum has to be able to share that not public data with DHS, because that's not a violation of Chapter 13 to share it basically within the government agency as they're both treated. The question is, does that data get out to the public? So it seems to me for this system to work, if I'm understanding this correctly, Optum has to be able to share not public data with DHS for DHS to do its job that this legislature is tasking it with doing, or has tasked it with doing, to protect the public purse. And if the legislators want to have the oversight capacity as well, they would also need to have access to that not public data. But it's still not public data. So we can't ask Optum to redact all of the not public data from the report to DHS, because DHS then simply couldn't do its job without simply accepting without scrutiny whatever Optum has concluded, which I think we also do not want. So the A6 amendment simply would disrupt the entire system of DHS being able to rely on a report from a private contractor and decide what action to take. Because it would simply force DHS then to release all this not public data. And if they don't get it, they can't do their job of oversight on Optum. So, I mean, if someone thinks I've got this analysis wrong, please tell me. It could well be the case, but that's the way I'm looking at it right now. Senator Holmstrom, you wanted to follow up, and then I know we've got a few others who want to speak as well. Senator Holmstrom.
I'll let the others go.
All right. Senator Kroon. Senator Westrom.
Mr. Chair, you could not have argued more eloquently for the passage of this amendment in your last statement, and so I just wanted to raise the issue, and thank you for that, but take that one step further. DHS can't do their job if it's redacted from Optum we can't do our job if DHS and Optum redact all this information and we have no way to track down. And so therein lies the reason we should pass this amendment out unanimously. Thank you for your good analysis.
Senator Kroon, did you want to go now, or should I go on to someone else? Senator Kroon.
Thank you, Mr. Chair. I was going to point out the requirement in 1305 subdivision 11. And maybe the rub here is that maybe we just make Optum do that redaction under 1305 subdivision 11, and then it gets immediately released, then it should alleviate the concerns that you have.
Except that, Senator Kroon, then DHS would not be able to make their own assessment of whether the Optum report is reliable in every respect, or whether they agree with the conclusions that are drawn, let alone what enforcement or other action to take in response to the report, if they don't have access to the underlying data.
Mr. Chair?
Senator Kroon.
Thank you, Mr. Chair. Then they can send DHS an unredacted version, and then they can send DHS the redacted version under 1305 subdivision 11, which gets immediately released to the public. The point here is that DHS can't be trusted to do the 1305 subdivision 11 redactions. And Optum, being a government contractor, already has the responsibility to do that in certain situations. There's a remedy for anybody who's harmed by it. So we just put that responsibility on Optum as a government contractor. The appropriate things get redacted, but DHS doesn't get the opportunity to over-redact.
I would assume there's a remedy for over-redaction as well. If someone disagrees, thinks there's something that was redacted that shouldn't be, there must be some kind of a process in Chapter 13 for an ALJ to take a look at stuff in camera and make some decisions about what is or is not properly redacted. Ms. Primo, is that process there in Chapter 13?
Mr. Chair and members, I'm just pulling it up, but yes, there is, there's administrative relief, there's a civil action. There's also the opportunity to get a advisory opinion from the Data Practices Office, who try to sort of work things out between parties who may want the data regarding, certain over-redaction issues or other interpretation of various provisions.
Senator Westland.
Thank you, Mr. Chair. It's my understanding, and somebody can correct me if I'm wrong, but it's my understanding that the unredacted report has already been provided to DHS internal staff, to CMS staff, which is the federal government, and to the Office of the Legislative Auditor. So that information has already been provided to both federal agencies and nonpartisan agencies as well. My concern, which was raised originally by Senator Mohamed, is that the full unredacted report going out to the public would identify vulnerabilities and weaknesses that it is our job and the job of DHS and CMS collaboratively to try to address. And I do not think that those are things that we want to be telescoped to the general public. What I understand the original language in the bill to do is beyond DHS and CMS and the Office of Legislative Auditor, is that this now provides the information and the report to the chairs and ranking members of the committees with jurisdiction. So there's your oversight. The Commissioner of Human Services has to release the report to those committee chairs and those that have jurisdiction over this report. And I'm not seeing how releasing this broadly and widely unredacted to the general public serves the public interest. And so I will not be supporting this amendment, but if anything I've just said is inaccurate, someone could perhaps enlighten me.
Mr. Chair.
Senator Mohamed.
Thank you, and thank you, Senator Westland. All of that is correct, and I think it's important for us to note what's already been released by the report. And I'd like to just name that there was $52 million in direct recoveries due to policy issues that were discovered. There's $1 billion in potential recoveries that are achievable if we just clarify some policy language that is creating some ambiguity. And then there was $165 million that was a decrease due to cost avoidance after they implemented the prepayment review process. And the agency did come to our committee and did present to us that information, and they did make it very clear that what they redacted was the vulnerabilities within the report that would cause us more problems until we close those loopholes. I think it would create more problems and we would lose a lot more taxpayer money.
Senator Holmstrom, any final thoughts before we take action on your amendment?
Yes, thank you, Mr. Chair. So, first of all, Optum was already required to follow 1305 subdivision 11. So the report will already have the proper redactions in it. As a contractor, they're required to do that, as we've stated. But Senator Westland brought up a point, which is that there's oversight and there's reason to trust. And I think that the people of Minnesota don't feel that way. I think that the people of Minnesota, the reason that this bill is even being considered is because it is so clear that the administrative agencies have covered for themselves so consistently and so atrociously that we have to have these conversations. We can't trust the administrative agencies. And the people of Minnesota don't want to trust a select few legislators that may or may not have their best interest in mind. And I think that this is, no private data is going to be released with this amendment. And it is going to go a long way to build back trust with the people of Minnesota. Failure to do so is nothing more than jumping on in defense of administrative agencies that have robbed the people of Minnesota blind. I don't think people are going to stand for it, but that's up to your electors and your delegates this fall.
Senator Westrom, did you want to say something after the author of the amendment before we vote?
I did. I just want to request a roll call and have it recorded in the Senate Journal according to Senate rules.
Are there 3 hands for recording in the Journal? There are 3 hands. The vote will be recorded in the Journal. The clerk will take the roll.
Chair Latz,
No.
Vice Chair Uma Verbaeten,
No.
Senator Limmer,
Yes.
Senator Clark. No. Senator Holmstrom,
Yes.
Senator Kroon,
Yes.
Senator Pappas. No. Senator Seeberger,
No.
Senator Westland. No. Senator Westrom.
Yes.
There being 4 votes in favor and 6 votes opposed, the amendment is not adopted. Is there any further discussion on Senate File 3861? And members, just for your information, the intent is to move it on to the Committee on Finance. Any further discussion? Senator Holmstrom.
Thank you, Mr. Chair. I would like to offer the A7 amendment.
Senator Mohamed, have you seen a copy of the A7 amendment?
I have, Mr. Chair.
Senator Holmstrom, would you please describe your amendment? It's in members' packets.
Yes, Mr. Chair. So this would delete on page 18 subdivision 6, which is a required permission to conduct on-site inspection. And this would include harsher language or more strict language that would require DHS to actually conduct these inspections on all new applicants, on all reapplying applicants. And I think, again, we want to, and sorry, also anybody who's revalidating their license. Again, we're trying to implement safeguards to protect the welfare and the spending dollars of Minnesotans. I think this goes a long way to build back that trust, and I would hope to have everyone's support.
Senator Holmstrom, this portion of the bill is not within this committee's jurisdiction. This would have been something to consider back in Health and Human Services, but not really in the Judiciary Committee. Senator Mohamed, what's your position on this amendment here?
Yeah, thank you, Mr. Chair. You're right, it's not germane to this committee, but I will say I do have another proposal that does require site visits that are anonymous, and I can send that bill over to you if you want to co-author it.
To me or Senator Holmstrom that you looked at?
Both of
when
you.
said that?
If you'd like it, Mr. Chair, I was looking at him, but to Senator Holmstrom, since you care about this issue, and this bill actually tackles a lot of those issues, but we have a bill dedicated just to site visits, and I'm happy to send that to you.
All right, well, members, first of all, Senator Mohamed, I will be glad to join you as a co-author on your other proposal, if there's still room on the bill. I'll defer to Senator Holmstrom if there's only one slot left on the bill, if he wishes to co-author that with you. Members, I'm going to oppose the A7 amendment for no other reason than that it's not properly, I can't rule out of order. We don't have a germaneness or jurisdictional restriction on committee activity, but this really is something within the expertise of a different committee, and so I don't think it's fair for us to weigh in on this one. So I'll be opposing the A7 amendment for that reason. Any further discussion on the A7 amendment? Senator Westrom.
Mr. Chair, I think I heard you say the same thing, but there is no germaneness issue with amendments in committee. Is that what you just said?
That's what I just
Yep.
said.
Okay.
The people can factor in that element in determining how they wish to vote, however.
Sure. Very good. I'd urge members to vote yes.
Any further discussion on the A7 amendment? Senator Holmstrom.
Thank you, Mr. Chair. Senator Mohamed, I'm glad that you have another bill that does this. Unfortunately, there are 5,000 bills plus in this legislature. I'm not sure if it's going to get time to be heard. This bill is aimed at solving problems specifically in these programs. This is a perfect spot for this amendment. It fits perfectly in this bill. I can't imagine a better bill for it to go into. And it sounds like you agree with the concept. So I think it makes sense to move forward with this amendment. I would ask for everyone's support simply because it makes sense and it is common sense. It's what people of Minnesota expect us to be doing, putting guardrails where the administrative agencies have failed to protect us. And this is our job. I think this accomplishes it. And I like everything else about this bill. So I would like to see this added. And I'd ask for a roll call.
And
There'll be a roll call. Clerk will take the roll.
And for this to be added to the journal.
Pardon me?
And thank you, Mr. Chair. I'd like to ask for a roll call and for the results to be posted in the Senate Journal.
Are there three hands? Seeing three hands, the results will be in the Senate Journal. Clerk will take the roll.
Chair Latz,
No.
Vice Chair Umer Verbaeten,
No.
Senator Limmer,
Yes?
Senator Clark. No. Senator Holmstrom.
Yes.
Senator Kroon,
Yes.
Senator Pappas. No. Senator Seeberger,
No.
Senator Westland, Senator Westrom.
Yes.
There being 4 in favor and 6 opposed, the A7 amendment is not adopted. Any further discussion on Senate File 3861? I'm not seeing any further discussion. Senator Westland, would you move adoption of Senate File 3861 and its referral to the Senate Committee on Finance? All those in favor say aye. Aye.
Aye.
Opposed? No. Motion prevails. All right, thank you, Senator Mohamed. Senator Kupec, you're up next. Senate File 4255, Senator Kupec on emergency managers. Members, this is the original jurisdiction on this For this committee, it's all within our jurisdiction, and I have counsel. Hold on. So members, there's a bit of ambiguity about the role of this committee as opposed to state and local government or labor. So the president's office referred it to this committee. And so what I'm going to recommend is that we give the bill the hearing, we have the testifiers here, and then the next stop would be state and local government. I'm going to recommend that if it gets the support, then we pass it out of this committee without recommendation and re-refer it to state and local government. Senator Kupec, why don't you give us a brief description of your bill, please, and then we can hear from your testifiers briefly as well.
Sure, absolutely. I feel like this is maybe a little palate cleanser bill after maybe the last two. So this bill aligns emergency manager roles with public safety and employment expectations, existing required state statute responsibility. It's consistent, it will bring consistency across Minnesota jurisdiction and codifies the long-held standards. This bill helps with workforce recruitment, retention, and professional recognition. It's a core tenet of the emergency management, which is responding to critical situations and emergencies as they arise. So basically what we're doing is we're saying emergency managers are essential personnel in the state of Minnesota, which as somebody who in previous life worked with emergency managers was surprised that emergency managers were not considered essential personnel within the state of Minnesota. So it's a pretty simple bill. And it doesn't cost anything.
All right, Senator Kupec, your testifiers here. I have Aaron Hughes. Go ahead and introduce yourself and your position and give us a minute of testimony as to why we should act on this bill.
Thank you, Mr. Chair, members of the committee. I'm Erin Hughes. I'm the emergency manager for Stearns County, and I'm here today on behalf of the Association of Minnesota Emergency Managers and my numerous colleagues around the state to talk a little bit about why emergency management and the essential employee designation is important to our field. First of all, emergency management isn't something that only matters when we have disasters. It matters day to day, year round, behind the scenes, because we need to make sure that our communities are safe for the people who live, work, and visit throughout the year. Emergency management protects lives, whether we're dealing with severe weather, infrastructure failures, cybersecurity incidents, or public health threats. Every major event requires fast, coordinated action, and emergency managers provide that coordination by bringing together responding agencies so that the public gets timely, organized help when it matters most. We keep the government functioning during disruptions. When we have those events like severe weather and infrastructure failures, we stand up emergency operations centers to support leaders who need to make urgent decisions, to ensure accurate information is provided to the public, and to keep essential government services running. Without this coordination, response efforts can quickly become fragmented or, for certain, slower than they need to be. We serve a unique role. We aren't law enforcement, we aren't firefighters, we aren't public health, but instead we connect all of these disciplines together so that we can make effective and timely decisions for our communities. We help build and maintain plans and partnerships and communication systems that make coordinated response possible. We do this work every day. We don't have crisis necessarily every day, so we work on assessing risk, developing plans, managing grants to support preparedness. We partner with hospitals, schools, utilities, and businesses. We help teach the public on how to be prepared, and we certainly maintain a constant state of readiness. It's continuous, proactive work that is designed to make our communities safe long before disasters happen. Emergency managers work alongside police, fire, and EMS and other essential services and other essential employees, yet we are not formally recognized in the same way. Aligning these designations simply reflects the reality of the role and strengthens Minnesota's overall emergency management system. In short, Minnesota cannot prepare for, respond to, or recover from emergencies without its emergency managers. This work is already essential in practice. We're looking for statute to acknowledge that. Thank you.
Thank you, Ms. Hughes. Eric Wage.
Thank you, Mr. Chair. Members, my name is Eric Wage, spelled W-A-A-G-E. I'm the Emergency Management Director for Hennepin County, and I'm representing the Association of Minnesota Emergency Managers on this bill. The membership is pretty clear that this would have a positive impact across the entire state from rural to metro, so this isn't a particular issue that centers on one particular area. It would help ensure the successful coordination of crisis operations for those already listed in this bill. There's quite a number of professions that we already coordinate with. It would also ensure that the effective coordination with private industry and voluntary agencies occurs, and we're really the center of that type of coordination in a disaster and emergency. I think, excitingly, this doesn't cost any money, so we can put that down as a positive. Many have expressed surprise that we're not already included in this list of essential employees. And de facto, we're already seen that way now, but we are seeking this formal designation to be spelled out in statute because there's many different cases of emergency management organization throughout the state. And in many instances, local emergency managers are already planted inside law enforcement entities, fire departments, public health agencies that are already included in this designation, but then there's also a significant number that are not. And so we don't want to create or maintain an environment where we have two different categories of emergency managers, one that are essential, one that aren't. So we're hoping to bring this together and clarify this through this law. Why is emergency management essential in emergency response? Is because we do things in support of our more famous first responders or in the fire service and law enforcement and others. They're centered right now on the immediate circumstances that are occurring, and we take some pressure off them by planning the next phase and the next operational periods and things like that so they don't have to. They can concentrate on what's going on right now. We also take responsibility for the things that are going on away from the incident scene. So if there's evacuees that need to be received, mass care that needs to be done, sheltering, other kind of stuff, we take that off the plate of the first responders. And then we also trigger the initial stages of recovery and utility restoration and restoration of lifeline services, again, so that those on the scene don't have to be thinking about that. And why is it important that we're essential even during non-disaster periods? And I will say that the tempo is increasing in disasters and that space in between disasters is shrinking, but there still is some time. And so it's our job to ensure readiness, that planning with other agencies occurs. We maintain equipment that's response ready. We monitor hazards, including shifting weather conditions, special events, cyber threats, and other situations. And we must always be ready to notify our leadership, our elected and other leaders, warn the public, and activate emergency operations centers immediately for response to take place. So we appreciate your consideration of this bill. We appreciate your longstanding support through the legislative actions you've already taken and many different things. And so we look forward to working with you, and we'll answer any questions you might have. Thank you.
Thank you, Mr. Wage. Any questions from members of the committee? Senator Limmer.
Thank you, Mr. Chair. Mr. Chair, or maybe this is directed to council, I'm somewhat confused about whether or not we have jurisdiction or not. I would think we would, simply because emergencies that are so described with the other personnel listed in the bill under subdivision 7 certainly falls under the jurisdiction of the Department of Public Safety. So I'm a bit confused why we would not include emergency managers unless there's lack of a definition of what emergency manager is, or perhaps it might need to be refined in order to fit into the jurisdiction. But perhaps council could tell me if why there is a confusion.
Mr. Backus.
Mr. Chair and members, generally speaking, this committee doesn't see similar bills like this. This is a Chapter 179A issue, which is I believe that's the Pelra law. Certainly this committee has an interest in things like emergency managers. And if you look at the current law, like on line 1.8, 1.9, you can see guards at correctional facilities, et cetera. I mean, clearly, the emergency managers are within this committee's jurisdiction, and this committee would have an interest. But the general thrust of the law really is more of a labor-type issue, and I think that would be the state and local government committee's primary responsibility, or the labor committee, I'm not sure which.
Okay. Madam Chair.
Senator Limmer.
Thank you. Madam Chair, I can now understand it's more of a labor issue. However, I would think it would be a shared jurisdiction simply because the Department of Public Safety certainly is in our jurisdiction, and we certainly manage to a degree the functions of all of these professions: peace officers, firefighters, guards at correctional facilities. They're all essential. And I don't see why we would not have any problem recognizing emergency managers in this list. They're highly trained. You just can't pull someone off the street and put them in the job. They need to have a vast knowledge of the available resources and to manage it in certain directions. I certainly would think that we could make it a motion to recommend for passage and then submit it to the appropriate labor committee. But thank you, Madam Chair.
Madam Chair.
Senator Kupec.
If it sheds any clarity in the other body, this bill originated, I believe, in their labor committee and then went to their judiciary or public safety committee. And that was the path it took in the other body.
Any other questions or comments from members of the committee? Senator Pappas. Madam Chair, I'd like to move that Senate File 4255 be recommended to pass and sent to the Committee on Labor.
Madam Chair.
On that, Senator Westrom, do you have comments on the motion?
I do. Well, discussion on the bill. Madam Chair, I guess Senator Kupec, I'll start with you. So has there been an issue here of emergency managers threatening or going on strike that we've had in the recent past? And are they part of a union right now in all cases?
Senator Kupec.
I will take a quick stab, and then I'll let a testifier who probably knows better. But it is my understanding that because counties appoint different people to be emergency managers, I know in my county we have a sheriff's deputy that is the emergency manager. So that person is covered under. They have already different rights than a regular emergency manager. They're already essential personnel. They'd be covered probably by a different union as well, but this just brings everybody in the state under the same definition.
Madam Chair, members, Senator.
To the testifier.
There are many different ways of organizing across the state, and so some are unionized, some are not. Some are, there's just many different departments that they're attached to. In fact, the Hennepin County Emergency Management prior to 2011 was in Public Works, for example. So they're all over the map. Some are essential, some aren't. And it's really hard to describe what the consequences might be in the future of having that not clearly defined in law. So we're just hoping to finally just nail it down and just put us all in essential category.
So Madam Chair, so
Senator Westrom.
Senator Kupec or to the testifier, if a county doesn't have a unionized emergency manager, would it apply to them also? Or to the second part of my last question, is every emergency manager in every county part of a union, or is it some of each?
Some of each.
Mr. Waggy.
Mr. Chair, members, Senator, some of each. It's a mixture right now, depending on the jurisdiction or the county.
So Mr. Waggy, Mr.
Senator
Chair.
Westrom.
Would this allow the non-union public counties to stay the same? It just, they would have to go to work whether they wanted to or not. Also, if we had an essential employee designation.
Mr. Chair,
Waggy.
members, Senator, you know, emergency managers plan for contingencies and just try to forestall any problems. And so this is our way of, not that we have identified this as a specific problem that's immediate and right now, but we just don't want to have that type of problem emerge. And so creating a category where we're an essential worker just removes that from any problems in the future that we see.
So Mr. Chair.
Senator Westrom.
Mr. Waggy, and I guess Senator Kupec, a little to you as well. So does this really only apply to the counties that have union Department of Emergency Management staff? And would it do anything to force a change on the private or the counties that don't have unionized employee management? That's kind of the issue I want to get to, so there's not some unintended consequence here.
Mr. Chair,
Mr.
Senator, again, I don't think the only benefit of this designation is a union one, but I guess I'm not an attorney, but I just think that when you're designated as an essential, so for example, I'm not sure, I guess I don't know, I'm just speculating, but I'm not sure if all of the ones currently listed are union members under the essential category, whether assistant attorneys or superintendents of school districts or things like that are union. So there might be some other benefit to being declared essential, and I think when we look at the definitions of essential, it's usually because of a crisis situation or emergency of some kind. And since it is an emergency or crisis situation, that's why we're thinking that it might be useful to have an emergency manager be listed as an essential employee. That's our rationale.
Mr. Chair, Senator Kupec, do you have anything to add to that?
Senator Westrom.
Sure, I will just add that,
Senator Kupec.
Sure, thank you, Mr. Chair. I would just
I
add.
clearly lost control of the
You
committee
have,
here.
sorry.
You guys just go ahead.
I swear you said my name.
Last word on this jurisdictional question. sir.
Sure, I mean, I could foresee, let's, for instance, let's take a COVID emergency and only essential personnel are showing up. In my county, we regularly deal with floods in the spring, and we had one actually in 2020 during the COVID emergency. I would want my emergency manager to be able to come to work if it was only essential personnel. There are strange, who knows what in the future we would see where there'd be some emergency where we only need essential personnel. I want my emergency manager there.
Well,
All right,
Mr.
Senator
Chair.
Pappas, council has advised in consultation with council from other committees or staff from other committees that state and local government, it would be the appropriate next stop, not the Labor Committee. I understand while I was out of the room, you made a motion to refer it to Labor.
Mr. Chairman, some of it was just practical, is that state and local government tends to have a lot of bills and labor has more capacity. And also I've noticed that the chair often will waive jurisdiction from state and local. So I just thought it was more efficient because if we send it to state and local and then they waive it and then it has to go through the floor and then it has to be re-referred, just seems like, and PELRA has always been under the jurisdiction of labor.
Do we have any input from the chair of state and local, whether they want this bill, or they're willing to, are they going to waive jurisdiction? I really don't want to spend a half an hour on the jurisdictional question here. We don't have that time in this committee.
And Senator Kupec, you haven't heard anything?
Senator Pappas. Senator Kupec.
All I have heard, and while you were out, Mr. Chair, all I said was that the other body originated this bill in their labor
Senator
committee.
Kupec, I don't care what the year,
No,
what the
and
other
then
bodies.
Sure, and then it went to their
pathway
public
was on
safety,
this bill.
but wherever, I can see both having some say.
Mr. Chair?
All right, state and local has waived. Labor doesn't have jurisdiction, which means their only option is lay it over or send it to the floor, and I don't want to hang on to this bill.
Why doesn't labor have jurisdiction? Okay, send it to the.
This is
Mr.
what I'm
Chairman.
informed. So I think we should send it to the floor, and if some other committee wants to see it, they can deal with the powers on the floor and pull it into their committee.
Mr. Chairman, I would amend my amendment to say Senate File 4255 be recommended to pass and sent to the floor.
Is there any further discussion on this bill? Keep in mind, members, we're going to stay until we finish our agenda here today, and we are not even halfway through. Senator Westrom.
Mr. Chair, thank you for the side discussion. I had the floor, but I realize you had some questions to answer. I still haven't got a full answer to my question.
Maybe that's because should be in a different committee's jurisdiction, those questions.
Or they don't know, or they're being evasive. I don't know which it is, but it's
Senator
one
Westrom,
of
before you
a
accuse
couple
people of being
options.
evasive, you should be very careful where you tread.
What's that?
You should be very careful where you tread before you accuse people of possibly being evasive.
I didn't say they were, but they could be. I don't know, Mr. Chair, because I haven't gotten an answer to my question.
Well,
And I've asked, so many questions that the chair is irritated that I've asked so many questions and they haven't answered my question yet. So
Well, maybe
how am I
Senator
supposed to
Westrom-
proceed, Mr. Chair?
Senator Westrom, if you've asked a question 3 times and you're not getting an answer, what makes you think you're going to get the answer you're looking for with the 4th question?
Well, Mr. Chair, that's why I had the suspicion maybe they're trying to evade the question or they don't know, and I don't know the answer to that question.
Okay, we'll ask Senator Kupec or the testifiers. Are you trying to evade the question, or do you not know the answer to the question that Senator Westrom is asking?
Mr. Chair, to my knowledge, I have answered the question of everything that I am aware of. I was brought this bill. I was told we need to put it, they would like to put it in statute because some people are essential and some are not, and they would like one uniform across the state to put it essential. That is what I was brought. That made sense to me. That's why I agreed to author the bill.
Is there anyone else in the room that can give any further information in response to Senator Westrom's question? I'm not seeing anyone
So,
else
Mr.
that has
Chair.
anything further to add, Senator Westrom.
Mr. Chair.
Senator Westrom.
Ask Senator Kupec, you said they brought a bill to me and want everybody essential. Who's they? Who are we talking about as they?
Senator Kupec.
Thank you, Mr. Chair. It is the members who represent emergency managers across the state. I've carried other legislation for them. I have a good working relationship with the association that represents emergency managers, and they brought this to me, and I was happy to do it because I've brought other legislation for them in the past.
And can you,
Senator
Mr. Chair, Senator Cooper, can you give us the exact name of what this group of they is?
Association of Minnesota Emergency.
Senator Kupec.
The Association of Minnesota Emergency Managers.
Okay, so
Senator Westrom.
hopefully this can be clear enough. Mr. Chair, Senator Kupec, is there any way this bill will affect a county that doesn't have an emergency manager that's part of a union, that they would have to join a union, or can they remain the same if they're one of the counties that you referenced and your testifier referenced that doesn't have a union emergency manager?
Senator
I hope that's
Kupec or
clear
your
enough.
testifiers, if you know the answer.
From talking to my testifiers, it would be the choice of that person within that county whether they wanted to join a union or not.
Okay, thank you.
All right. Seeing no further discussion, Senator Pappas moves that Senate File 4255 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? No. Motion prevails. Thank you, members.
Thanks.
Senator Putnam. The next item up is Senate File 4205. The committee is properly warmed up for you, Senator Putnam.
Thank you very much, Mr. Chair. I will endeavor not to be as cantankerous and difficult as that Kupec character.
Members, this is the original jurisdiction on the bill. It's a proposed appropriation for an organization, and we have some testifiers here. So Senator Putnam, go ahead and give us a brief description of the bill. The intention is to lay this over for possible inclusion as we approach our budget deadlines. Senator Putnam.
Thank you very much, Mr. Chair and members, for an opportunity to talk about 180 degrees and to spend some quality time in the Judiciary Committee. Members, I think one of the last times I was here was actually to talk about 180 degrees last session. It's an incredibly important organization, especially in a moment like the kind of moment in which we find ourselves now. It is extremely difficult to be a young person today. So difficult that I'm actually glad to be old, as I assume so many of you are as well. It's a hard time to be a young person these days. And it's especially difficult time to be a young person who's made a mistake. Folks who are justice involved and who are young need support, they need help, they need wraparound services, they need direction, and they need people looking out for them right now. And members, that's what 180 degrees does. For years, I used to drive by this nondescript building in St. Cloud on West St. Germain Street. Had no idea what was going on there, didn't know that lives were being changed within it. And 180 degrees was working with justice-involved teenagers to get them on the right path. They are an established organization with a great record of helping people who need help. And as I suggested earlier, we have lots of young folks, in this case, age 18 to 24, who have been justice involved, who need a little bit of help with their second chance, to get a job, to find an apartment, to know how to get on the right side of life and to start making the right decisions. That's what 180 degrees does, Mr. Chair and members. And so what you have before you is a small appropriation to help them do that work, to help give people a second chance and help them make the right decisions as they do. Thank you, Mr. Chair.
Thank you, Senator Putnam. We have Dan Farr present to testify. Why don't you start?
Yeah, thank you, Mr. Chair.
Welcome back to the committee. I think you've been here before.
Yeah, my name is Dan Farr. I'm the CEO of 180 Degrees. What I'd like to share with you today is the story of how we began. In 1971, a man by the name of Robbie Robinson had been in and out of prison multiple times. He was struggling with addiction. When he came out for the last time, he said, I'm going to buy a building, I'm going to move my family in, but I am also going to offer this space to other men coming out of prison. We still have that building today. We serve over 350 men coming out of prison. Over the last couple of years, that age for us has gotten younger. We now serve over 40% of the people that we serve in this program are under the age of 24. And it has created some new challenges for us. The challenges are getting our younger folks through high school degrees, GEDs, getting into workforce training, getting into chemical health support groups, getting into mental health treatment. All these things are roadblocks that we have in moving our clients forward. And so this bill actually gives us the resources that we need to be able to hire case managers, job coaches, and others who are able to support this younger population as we move forward. We are the largest reentry organization in the state of Minnesota. And I wish I could tell you that that DOC, the Department of Corrections, offers us enough of a per diem to be able to do the work out of that pot of money. The reality is that it doesn't. It doesn't nearly meet the need that we have for these young men. We have 3 levels of housing. The first level is compliant, where we have guys coming out of prison, where we do the compliance for the probation and with the probation officers. The second level of housing that we have is more community-focused with what we call affordable rentals and affordable subsidies for guys to live independently in the community. The third level of housing that we have is called Great River Landing in a partnership with Beacon. This housing provides people like Dakota a chance to restart their life over again. And it also gives, other than temporary housing, it gives permanent housing if they so choose. So with that, I would like to, Mr. Chair, I would like to have you pass it over to our testifier, Dakota.
Thank you. Dakota Poplinski, welcome to the Senate Judiciary Committee.
Thank you. I just want to say that, you know, I haven't made the best choices, but this last time being released, you know, I got connected with some people and had my probation officer get a hold of Great River Landing, and if I wouldn't have had them when I got out, I surely would have been on the track to straight going back. You know, I had problems with substance abuse, but this place has gave me a stable place where I can focus on rehabilitation, getting a job, where I don't have to worry about where I'm going to sleep. I can focus on being a father. I can, you know, they connected me with services that are going to help me get a job. And yeah, just this is a really good place.
Thank you, Mr. Poplinski. Thank you for coming before us today, and congratulations on your success.
Thank you.
All right. Any members of the committee have any questions or discussion relating to the proposal, which we will be laying over? Senator Holmstrom.
Thank you, Mr. Chair. Senator Putnam, I noticed that this is a named grant. Is 180 Degrees Great River Landing in Clifton Place the only organization in the state that offers these services? Or could this be a competitive grant?
Senator Putnam.
Mr. Chair, Senator Holmstrom, thanks for the question. I think there's something special about the way that 180 Degrees does the work that it does. It is not the only reentry program in the state, but it is clearly a well-established one, you know, beginning again in the early 70s. And as Mr. Farr mentioned as well, it is the largest and the one with the greatest credibility.
Mr. Chair, can I add to that?
Mr. Farr.
Thank you. And what I would say about being named is that it allows us the opportunity in this part of the world where reentry services are solely oftentimes funded by per diems, right, coming from the Department of Corrections, coming from Hennepin County, and coming from federal sources. Along with those per diems, it is really hard to raise money for this population. And to give you an example of how our per diems are set, our per diems for our youth shelters are 3 times higher than the amount that we get from the Department of Corrections, from the federal government, and from Hennepin County. And so we actually subsidize hundreds of thousands of dollars into our adult programs that we have to, that we get that is left over on the youth side from our per diems to be able to do this work. And so it stretches us. Currently, we have a $250,000 deficit in our adult programs because of the lack of per diem and the lack of funding.
Senator Holmstrom.
Thank you, Mr. Chair. I have no doubt that your organization is doing great work and that your organization should be awarded the grant if the grant were to go out. However, I think if we look at the governor's proposed budget, supplemental budget recommendations, he specifically recommends that all state-funded grants be awarded through a competitive process. I think that that's, forgive my bipartisanship, I think that that's good advice. My recommendation would be to do that. I don't have an oral amendment to offer right now, but I would like to see that on all of our grants, and I don't think I would support a bill in this legislature that isn't run that way, considering what we're facing. Thank you.
Senator Pappas.
Mr. Farr, just curiosity question. Do you remember way back, did there used to be a 180-degree facility on West 7th Street?
We are still, we still have Brittany's Place in St. Paul, and that serves sexually exploited girls. And so we have 4 youth shelters around the state. Those youth shelters are in St. Paul, Chanhassen. They are in St. Cloud and Rochester. All of our adult facilities for men coming out of prison are located in Minneapolis.
And where's the facility in St., I'm sorry, Mr. Chair. You know I do that. Where is the facility in St. Paul? Tell me again, I didn't hear that.
It is on actually East 7th Street.
East 7th Street.
Yep, 1301 is the address that we use. It is our administrative building next door to the shelter. We don't generally give out the address of the girls' shelter because of the domestic violence and sexual violence that they've experienced.
Any further discussion? All right, Senate File 4205 is laid over for possible inclusion. Thank you, members. Next up, Senate File 3599, Senator Putnam. Members, this comes to us from the Housing and Homelessness Prevention. Actually, it wasn't considered there. It's withdrawn and re-referred here. And the anticipated action is to lay it over for possible inclusion. Senator Putnam, also, there's some thought maybe Housing had an informational hearing on this. Can you tell us if that's the case?
Thank you, Mr. Chair. Yes, this was heard in Housing.
Okay. Why don't you go ahead and give us a description of the bill, and then we'll have discussion and testimony.
Thank you, Mr. Chair. So this bill is actually fairly simple, and it's a simple solution to a tremendous problem. Members, you are probably aware that Minnesota sits on the precipice of a massive eviction crisis, not due to any specific event or moment, but merely to the problems that we have in housing, period, when it comes to affordable housing. Last year, there were 25,000 eviction cases in the state of Minnesota, a record up 2,000 from the year before. And in the month of January alone this year, there were 2,200 eviction cases in the state of Minnesota. This is a problem that is happening in the world. It's a problem for those individuals and those families who live in those homes, but it's also a problem for those landlords who need to get paid their rent. And so the current situation that we have right now is that there are government entities who work in the rent assistance area who are able to provide a letter of support committing that the rent will be paid. All this bill does is it changes the definition of what an acceptable organization would be to provide that assurance. That letter is supplied under penalty of perjury. It is perfectly well established and reliable. And basically what we're saying is that right now, if you're about to get evicted, you can get a letter from your county that says, we're going to send you assistance, you're going to be fine, you can stay in your house, your landlord knows they're going to get paid. All we're doing is expanding that to say, hey, if a church does this work and has this capacity, they too could write a letter, again, under penalty of perjury, guaranteeing that that rent would get paid. So all we're talking about is expanding the number of organizations so that it's not exclusively government organizations, but organizations that have a history of working in rental assistance who could then testify to the actuality that this rent would get paid by this other organization or by assistance from this other organization by the date that it's due. It's pretty simple. Makes a lot of sense, I think. Given the severity of the crisis that we face, we need a lot of people helping. And the best thing about this is it helps people help each other, which I think is one of the things the government should be doing. It shouldn't be just on government to help people out of these circumstances. And what this does is it opens up the field so that others can. That's the essence of the bill, Mr. Chair.
I'm not aware of any specific testifiers signed up in favor of the bill. We do have one testifier signed up opposed to the bill, Cecil Smith from the Minnesota Multi-Housing Association. Mr. Smith, why don't you come forward?
Let's go. Good to see you.
Mr. Smith, go ahead and introduce yourself and give us your testimony, please.
Thank you, Mr. Chair, members of the committee. My name is Cecil Smith. I am the President and CEO of the Minnesota Multi-Housing Association. MHA is an industry nonprofit representing 2,300 members and over 300,000 rental units, which are home for over 600,000 Minnesotans. I'm here today to respectfully raise MHA's opposition to Senate File 3599. We appreciate the goal of encouraging payment solutions that allow residents to remain housed. Housing providers regularly work with residents and rental assistance programs to resolve non-payment situations, and written guarantees from government agencies are already a common and effective tool. Our greatest concern is with the addition of any third party who can provide a statement under penalty of perjury that funds will be provided. Lacking a clear definition, this could include anyone, a friend, acquaintance, an unknown individual, and represent a significant expansion beyond the current functional framework. This change removes important guardrails that help ensure the guarantee is reliable and verifiable. Additionally, if funds are truly available, this step is unnecessary. A third party with sufficient funds could simply provide payment directly and promptly, as is commonly done today by religious organizations and social service providers. Instead, this proposal allows a tenancy to be restored based on a promise of future payment and unilaterally dismisses a matter before the courts. Finally, the proposal creates a situation where the housing provider has little recourse if the statement is made, but the funds are never delivered. The provider must restart the eviction process. That delay can increase financial losses and operational challenges, particularly for small housing providers. Given the uncertainty this policy would cause, we encourage the committee members to oppose the proposal. Thank you for your time. Thank you.
Mr. Smith, there are two parts to the bill before us. One is that provision, the new paragraph or clause 3. There's also on line 2.1 the deletion of the word government. Does your objection extend to that, the deletion of the word government as well, or is your focus on clause 3?
It extends to both. I was just limited in my time of testimony and raised our greatest concern, Mr. Chair.
Okay, could you perhaps elaborate a little bit more on your objection to a 501c3 that is not administering a government program, but administering a rental assistance program? So it wouldn't be any third party, but it would be a 501c3 organization. It just, without specifying the source of their funds. Mr. Smith?
So our concern is if the funds are readily available, then the funds can be issued. We understand that with governmental programs, there is often a delay in terms of check processing through the control systems that especially some of the larger counties have, where they're only cutting checks twice a month. And so there has been a practice in the industry where letters of guarantee have been issued by county governments, social service providers, that the county government, in offering that rental assistance, has provided housing providers with a letter of guarantee, which has allowed for the case to be dismissed before the courts, and we just wait for the check from the county government. To eliminate that would mean that 501c3s, which may offer a guarantee, but we're still subject to their solvency, which is unknown, does not carry the strength of a county government that has a known budget providing rental assistance.
Any further questions or discussion of Mr. Smith? All right, thank you, Mr. Smith. We'll open it up for committee consideration. Senator Kroon, then Senator Holmstrom.
Thank you, Mr. Chair. So I also have concerns about the broad nature of a third party in this bill. I mean, it could be your buddy, it could be anybody. But my question is, like, given that the broad nature of that term, what happens if they don't come through? Like, what position does that put the landlord in? What do they have to do?
Senator Putnam.
Mr. Chair, Senator Kroon, I think it's a fantastic question. And I will say that it's interesting to hear the dynamic of trust in the conversation, and that it's curious for me in some ways that we're having much more trust in government than we do in some of our local organizations. And I say that to be slightly silly. But on that point, having someone sign a letter that they are guilty under penalty of perjury I think is a pretty significant expectation for someone. So there are clearly consequences for those who sign the letter, but maybe not as much for the landlord, which I think is perhaps your point. And I think that that's a valid point. I hesitate to mention, I'm not sure if I can say this in code so as not to irritate the chair, but the lower body. I hope that by referring it to the lower body instead of the other body, the chair will still indulge me. As this bill
Since you put it
was,
that way, Senator, go right ahead.
when this bill was in that space, that section was struck. The third portion was struck, and that's something I'd be amenable to. But I do disagree with Mr. Smith, respectfully disagree with Mr. Smith's characterization of the or portion. Those are organizations that are actively already doing this work. So taking out the fact that it's coming from a government or not, I think is a really significant distinction. So to your point, Senator Cruin, I completely understand the and other. That does sound kind of vague. I completely agree with you on that front. That makes sense to me. But the other part, as the chair referred to, expanding it to organizations that are already doing this work, official nonprofits that are already doing this work, I think that's an important change. And especially given the severity of the crisis that we face right now. We need more hands on deck to help.
Chair.
Senator Cruin.
Thank you, Mr. Chair. Yeah, I mean, if you can open it up to a third party at a minimum, and I don't think even this would be sufficient, like that would be, we'd have to add a cause of action or something by the landlord to that third party. And even that's not really fair because the landlord didn't voluntarily enter into a contract with this random third party who may or may not have any money. I understand it's under penalty of perjury, but you and I both know, or at least I know, that those cases are almost never charged. It's extraordinarily rare on a minor, relatively minor thing like this for county attorney to bring a perjury charge against somebody. So I'm not sure that that really is any kind of assurance to me. So I would like to see the third party struck entirely. As far as the other point, what is your response to the argument that if these 501c3s are legitimate organizations that are doing this kind of work, why wouldn't they just have the money up front to bring it current? Why would they have to do it later on a promise?
Senator Putnam.
Mr. Chair, Senator Cruin, I think that also is a valid point, but these are the language in the bill itself says 501c3 nonprofits that have already been doing this work for some period of time. So I'm assuming that they have very similar constraints and dynamics that Mr. Smith pointed out the government has. And it's sometimes you got the cash flow, sometimes you need a week. So I think if you're looking at like it's May 2nd and you know you're not going to have your rent by May 31st, getting a letter from an organization that says, yeah, you're going to be cool on May 31st, even though that organization doesn't cut the check on May 2nd, I think is just as helpful and just as important because it keeps that family in their apartment, in their house, keeps that family together in their home.
Senator Holmstrom and then Senator Limmer.
Thank you, Mr. Chair. So when I try to think about this from the perspective of the landlord, who's obviously an interested party here, and if a third party says they're going to bring payment and they fail to, whether or not that third party is charged with perjury, the landlord is facing the cost of creating a new eviction action, which in 86 of the 87 counties means hiring an attorney, and the cost is $1,500 to $3,000 minimum. And that means that a landlord could be buried $6,000 into an eviction or more simply because somebody lied to them. And it's putting these guys in a pretty bad place. You don't usually bring an eviction because somebody's 1 month behind on rent. So we're talking doubling potentially the damages to a landlord in this bill. And I think it's going to drive up the cost of rent for all Minnesotans because landlords can't afford to eat all that all the time. So I don't know that the third party makes sense to have in this bill. I don't know if it's clean enough language at this point.
Mr. Chair?
Senator Putnam.
Yeah, I appreciate Senator Holston. That's a good question, and as my answer to Senator Cruen, I think, established pretty clearly, I'm not wedded to that last clause or that last phrase in the clause. But I will say I'm glad that you brought up the expenses to landlords, because it's in the landlord's best interest to have assurance that the rent will get paid as well. So making sure that there are more organizations that are able to provide that assurance. And again, without that last bit about or any other organization, we're not talking about fly-by-night groups. We're talking about well-established groups. And so that assurance could forestall the initiation of an eviction, which would then de facto save that landlord money. And again, we're talking, I think, vacillating as we often do here between specific examples and large trends. But in this case, I think that there's a great opportunity where this could actually kind of help a landlord out a little bit so that they knew that they were getting the rent. And I think that's what everyone wants. We want the landlord to get paid. We want the family to stay in their house. And the best way that we can do that is what we need to do. And I think this helps a little bit. It's not solving all the problems in the world, but I think it helps a little bit.
Senator Limmer. I'm sorry, Senator Holmstrom, did you have
Yeah,
a follow-up? I wasn't sure if you were turning on or off your mic.
Fair enough, Mr. Chair. Yeah, I was going to move that we strike everything after the first comma on line 2.2, and then strike 2.3 and 2.4, which would be the section 3.
All right, Senator Holmstrom has offered a motion. Senator Putnam, what is your position on that?
My position, Mr. Chair, is that I don't have a copy of the bill in front of me right now, which means my position is unprepared.
That's a dangerous position to come in front of this committee.
If you could, Mr. Chair, repeat the...
You can take a minute to take a look at the bill, Senator Putnam.
Mr. Chair, are we speaking exclusively of line 2.2 to 2.4 after the comma or number 3 and removing that sentence?
Senator Holmstrom.
That is correct.
Senator Putnam.
As I suggested earlier, Mr. Chair, I have no issue with that.
Any further discussion? Wait, we may have some clarification on the language here.
Mr. Chair, may I ask Senator Holmstrom a question real quick? Sorry.
Senator Putnam.
Mr. Chair, I'm just curious. So we are talking about that comma or number 3, not about the striking of the word government in 2.1. Is that true?
Senator Putnam, the motion is to delete the new language on lines 2.2 to 2.4, and then would have to on line 1.23 delete the change on that line as well, or reinstate the stricken language on line 1.23.
Thank you, Mr. Chair. I do not find that objectionable.
Any further discussion on Senator Holmstrom's motion? Not seeing any. All in favor, say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Holmstrom, shall I move on to Senator Limmer now? Senator Limmer, nothing. Senator Westrom.
Mr. Chair, question I have, Senator Putnam, is what kind of timelines are we looking at? I don't really see a specific timeline. It's just a letter, and then how are we, it says it has sufficient funds. How do we verify that? It doesn't say that they have to be verified. Using an analogy, when you're buying a home with a realtor, typically when you submit an offer, your offer is strengthened, and some sellers only will allow offers that have pre-approved funds. So you have to either send along a bank statement or a letter from a bank that says so-and-so is approved for this much money. How are we going to identify sufficient funds or allow that to be verified if this was to go through, which I'm not necessarily thinking is ready for prime time yet, but if we did, what would be the way to verify sufficient funds?
Senator
and what kind of timeline are they going to have to pay with it?
Thank you, Mr. Chair, and thank you, Senator Westrom, for those questions. The language about has sufficient funds is what we just struck from the bill. So that language is no longer there.
Senator Putnam, it's also in
Oh, I see.
2.1 relating to
Sure.
rental assistance programs.
The other part to your question, the question of effective date, is that it's effective immediately and moving forward. So yeah, that's the best answer I can give you, Senator Westrom, on those questions.
And Mr. Chair, Senator Putnam, I wasn't wondering about the effective date. I was wondering about the effective, if the letter comes, are they going to say they're going to pay it within 2 days? Or can the letter say, we'll pay you within 6 months or 2 years, but we have sufficient funds? So I just think it's vague on how, it's at least not stated in there that the letter, they have to prove sufficient funds. And it doesn't say within 48 hours or within 1 week. There seems to be that there should at least be a minimum reasonable time period as a maximum. A letter saying you're going to get paid in 6 months, and then you've got the tenant can redeem. What if they default the next 6 months and you still haven't gotten paid from the first 6 months under the letter of so-called credit? You see where I'm going with this question?
Mr. Chester Westrom, yes, I do, and I think that the curiosity makes a fair amount of sense. My answer, though, is that it's under, I expect, the same kind of expectations as the government programs do. So the same sort of due dates, expectations, guidelines that are around the county programs where these resources are coming from would then equally be applied to the other organizations, 501c3s, that have an existing rental assistance program. So to me, as the bill is currently constructed, it simply says that the way things have been doing with the county, that works. We're going to do the same thing, but let a couple other groups do it, groups that we trust and that we know that have been doing this work for a while.
So,
Senator Westrom.
So, Mr. Chair, I don't quite have it ready yet on the fly here, but I think an oral amendment could be easily. So I'm thinking maybe in the front of the word sufficient funds that we should add the word with proof of sufficient funds, because that means they're going to have to show something. They might have to show a bank account or a rent escrow account that they have for this. So that'd be one idea for an amendment. I just want to get your idea. And then that to be paid within, let's just say, I don't know, 3 business days or 1 week, some timeline, so there's kind of a closure to this. If we're going to go with this letter of credit idea, then I think there needs to be some tighter windows on it. So I'm wondering if that's something you're amenable to.
Senator Putnam.
And council can look and help give me some suggestions while we're talking.
Mr. Chair, Westrom, I understand the reservation here, but I would go back to my earlier answer and say that we're essentially talking about the same thing that government does. So whatever expectations we have for government, we should have for programs like these.
And
Senator Westrom.
Mr. Chair and Senator Putnam, do you know what those expectations are? And are you open to an amendment that would at least match those timelines to help strengthen this language if it's going to pass?
Senator Putnam.
Mr. Chair, Senator Westrom, no, I do not have the exact details of what current expectations are for county programs that do this work. But again, Mr. Chair, if I may continue, my expectation or my hope would be that they would be the same as those that we would expect from these established organizations who have been doing this work for some time. And if there's language necessary to make that more clear, that these would be equivalent expectations, I do not fundamentally object to such language.
Mr. Chair, I'm going to try to work with staff a little bit on an idea here. I'll pass for now, come back and maybe have an amendment.
All right, I remind members, the plan is to lay this bill over, so if we can't figure out language while we're in committee here today, there will be further opportunity to work with the author to come up with language that might be satisfactory. Senator Holmstrom.
Thank you, Mr. Chair. With your permission, I'd like to invite Cecil Smith to come up and answer the question that Mr. Western was asking about what the time frame usually looks like.
Mr. Smith, come on forward.
Mr. Chair, Senator Holmstrom, what we typically see is counties have a check cycle. I'm most familiar with Hennepin County to do a check cycle twice a month. And so housing providers in Minneapolis and across Hennepin County can reasonably expect that they will see their letter of guarantee honored within the next 14 days. I will point out that the way the language is in 1.24 and onto 2.1 is that it's any 501c3 can establish a rental assistance program. They're not saying that they're mirroring a government rental assistance program. The deletion language removes government. So even though the government assistance programs might be running on a check cycle, there's no obligation for the 501c3 that's been established to provide a rental assistance program to honor that same protocol.
Senator Holmstrom.
Thank you, Mr. Chair. With that in knowledge, I think it would be appropriate to amend the bill to add 14 days. And I think a good place to do that would be on line 2.2, after the word landlord, comma, within 14 calendar days.
Mr. Smith, what's your response to that proposal?
So, Mr. Chair, our concerns regarding 501c3s establishing a rental assistance program is we have no mechanism for verifying the sufficiency of their funding. They can promise to pay it in 14 days and be honored and be required by statute, but again, we're left with a situation where housing providers now have to try and enforce that letter of guarantee.
Senator Putnam.
Mr. Chair, if I may, I think one issue with our conversation is that we are sort of characterizing these nonprofits as being completely without regulation, as being some sort of Wild West sort of pop-up kind of situation. But my understanding is that a lot of these agreements about these letters of guarantee occur in the context of actual eviction proceedings in court. So it's not like this is willy-nilly just happening. There's a judge involved, and that's part of the discussion. And part of why these letters of guarantee have so much credibility isn't because they come from the county or because they come from a 501c3. It's because they emerge in the context of an actual court proceeding, wherein there are consequences for shenanigans.
Senator Putnam, is there anything in the current statute that requires it be done in the context of, in front of a judge or in the context of a court proceeding?
Not to my knowledge, just that it is overwhelmingly that is the case.
Senator Holmstrom.
I guess I'm looking for more clarifying detail from Senator Putnam. And I recognize that sometimes this is a court action, but this bill doesn't address that every time it'll be a court action. And you yourself said that sometimes it means that we could evade court action just by simply offering this. So I think it's a reasonable addition. And we've taken out with the amendment the perjury part. So there's really nothing to hold anybody accountable in the bill right now. I think because we're expanding it beyond government, it makes sense to put guardrails on it. I think it was probably an oversight with the bill to begin with that there wasn't, because we just assumed government is good. Well, I don't assume that, but some may assume that government is good. So I would move that amendment, and I'm happy to repeat it if necessary. Mr. Chair,
Senator Holmstrom.
I would like to defer to Ms. Primo on the oral amendment, or the language for the oral amendment.
Ms. Primo. Whenever you're ready. Ms. Primo.
Mr. Chair and members, the amendment would be page 2, line 4, after the period, an organization providing a written guarantee under this paragraph must submit the payment within 14 days of submitting the written guarantee.
So, members, here's what I'm thinking. It sounds like there's some consistency within the committee about supporting the purpose of the bill. Maybe I'm reading it wrong, but supporting the purpose of the bill, which is to enable organizations that are not specifically administering a government assistance program to step in and provide some funds after the eviction notice has been brought. But there's some concern about the reliability of any such organization that steps in terms of the ability to pay, timeline for payment, capacity of the organization to meet whatever promises they make, at least to the level of reliability that exists in the current government assistance programs. Sounds to me like those concerns can be addressed with the proper language within this bill, but it's going to take us a while to reach that proper language, and I'm not entirely sure that simply putting a 14-day delivery date on it would meet all of those goals. I personally think that we ought to do something so that organizations that are raising private funds or funds from whatever sources that aren't government sources can step in and help a tenant redeem this. Even if they can do it now, this would set up a more formal structure for them to be able to do it, as long as we have appropriate guardrails and reliability standards in here. So I think what I'm going to suggest, we want to go, Senator Holmstrom has a right to move forward with the amendment if you wish to do so, Senator Holmstrom. But what I'm going to recommend that this bill is going to be laid over. And I would encourage the parties, anyone else who wants to be involved, to come up with some more language, see if there can be some agreement on that before the bill comes back before the committee. And we'll see if it reaches the threshold of being sufficient at that point. So Senator Holmstrom, would you like to move forward with your amendment? Either way, I'm not trying to telegraph to you one way or the other on that. But I'm going to suggest when we're done with that, we're going to lay the bill over so that the parties and any interested members can continue to work on language. Senator Holmstrom, what would you like to do?
Thank you, Mr. Chair. Seeing as though this was an oversight in the bill to begin with, I don't think it makes sense to hastily put together a solution to it. So I'm willing to pull the amendment and wait for it to come back to the committee.
Okay. I am saying we will bring the bill back before the committee. So we'll have an opportunity then to have an up or down vote or address any language issues at that point. But with that said, we're going to lay over Senate. Is that okay with you, Senator Putnam?
Absolutely, Mr. Chair. I think that's a good idea.
All right. Senator Westrom.
Just a
before we lay the
question in
bill over.
process. You said it will come back up for sure? Is that,
Yeah, the bill is being laid over for possible inclusion. It's my intent to bring it back
okay.
before the committee.
And you're
for
expecting an
consideration.
omnibus finance bill?
We're expecting there will be an omnibus package
Okay.
of some sort coming out of this
Okay.
committee. And
Because that would be the only path that it could take. On its own, it'd be a policy bill, but it would have to be in an omnibus bill. Very good.
Well,
That
theoretically, we could send it as a policy
Two
bill, as a
rules.
late bill. But we're anticipating putting together some kind of an omnibus policy bill that would include some budget components, so it would go to finance and fit within the budget deadlines for the.
Okay, that's what I was just getting clarification on.
Either way, it'd be
All
my
right.
intent to bring this bill back.
I'd like to work on it too if it's going to move forward, so thank you.
So Senator Putnam knows that Senator Westrom and Senator Holmstrom are interested in working on this as well. Anyone else who would like to, please let Senator Putnam know. And with that, Senate File 3599 is laid over for possible.
Thank you very much, Mr. Chair.
Thank you, members. Senator Boldon, why don't we take you up next? Senate File 4104. Members, the bill is being handed out. Members, this is the first stop for this bill. The anticipation is to lay this over for possible inclusion. And I don't have any testifiers listed in favor. I have one testifier listed opposed. Senator Boldon, why don't you describe the bill for us, and then we'll go to testimony.
Thank you, Mr. Chair and committee members. This is a very simple bill. It is already current law that a landlord is required to furnish heat at a minimum temperature of 68 degrees Fahrenheit in all places that are intended for habitation from October 1st through April 30th. That is the law right now. The bill before you would just extend that for 1 month on either side of that. So adding September and May, given that weather in Minnesota fluctuates. And there are times definitely in September and May when heat is needed. And this bill came to me from a renter. Actually was last May when we were having a cold, rainy spell. And he said that his apartment was pretty chilly and was asking me about this law, and we realized that it, ended on April 30th, and that is how this bill came about. Just that because of the weather here in Minnesota, it can be chilly still in September and May, and we want to be sure that people have warm temperatures in their homes during those times as well.
All right, I have one testifier signed up, Cecil Smith from the Minnesota Multi-Housing Association. Come on forward, Mr. Smith.
Mr. Chair, members of the committee, again, Cecil Smith with the Minnesota Multi-Housing Association. Housing providers share the goal of ensuring safe and habitable housing. The requirements in the statute include maintaining units in reasonable repair and complying with health and safety laws that are long-standing and strongly supported. Providers already work hard to meet these expectations, and the industry recognizes the priority of maintaining livable conditions for residents. However, MHA opposes the extension of the mandatory heat requirement from October through April to effectively Labor Day through Memorial Day. While well-intentioned, this change could create operational challenges, particularly during transitional weather months when temperatures fluctuate significantly. Extending the heating mandate may force providers to run heat during warmer periods, even when residents prefer cooling or when indoor temperatures are already comfortable. Additionally, providing heat for an additional 2 months, sometimes when it may not be necessary, can increase energy consumption and operating expenses, two categories that we should be trying to decrease. These costs put pressure on housing affordability, which remains a shared concern for both policymakers and providers. We would encourage consideration of flexibility when considering any changes to the minimum heat mandate, not expansions, which could better balance resident comfort, energy efficiency, and operational realities. We look forward to working with the author to ensure the policy supports safe and affordable housing while remaining practical to implement for housing providers when serving their residents. Thank you for your time.
Thank you, Mr. Smith. Is there any discussion from members of the committee on Senate File 4104? Senator Westrom.
Mr. Chair, first question, what did you say the plan of attack is on this, laying it over?
That's correct, Senator Westrom.
Okay. So, Mr. Chair, I think this is not ready for prime time, Senator Bolton, but have you thought about the scenario of buildings that use a central heat system, and you're now going to require that to be on till the end of May, is that correct?
Senator Boldon.
Thank you, Mr. Chair. I'm not requiring heat to be on during the end of May. What we're requiring is essentially the same thing that is already being required from October through April, expanding that out. And so the idea of, fluctuating temperatures, that can be true in October and April as well. What we want to avoid and are looking to expand these protections is for in September and May, during times when it can get cold, making sure that tenants have heat and warmth and safety and security in their apartments during those times as well.
So, Mr. Chair, Senator Bolton, the reason I ask you that question is, I don't know where you rent in town here when you're at the legislature, but the building I rent in, you would sweat me out of it. And so I am not at all interested in having the heat system on through the end of May. It's already on too long, and many times I have to be very inefficient and open the windows because there's heat on in April. And I'm not saying that's bad. It's part of the transition issue, but going to the end of May is unreasonable, very unreasonable. And then starting September 1st, that's still summer here in Minnesota. And the reason I'm raising this issue is I could point you to multiple legislators here that have moved out of the building I'm in because it's so hot in the spring or in the fall and uncomfortable to sleep in, and you're trying to make it more uncomfortable with this. Maybe not your intention, but I hope you're listening, because that's what your bill will do. Because when they have a system that was built in the 70s or 80s, they have to wait till the heat is shut off in order to get us cooling. And it takes a day or a couple of days to get that transition done. So I think you should maybe go visit some of the properties just within 5 miles of this Capitol and get that perspective, because somebody's got to stand up for the tenants that would be sweated out of these buildings. And I think the testifier just touched on that. That's why I think this bill is not something to support. Very, very overbroad, and think about tenants' comfort rather than mandating heat till the end of May and starting September 1st. I think I would rethink this bill completely, and I'm not interested in sweating myself out or having to have windows open because the heat is on and I can't get air conditioning, and there's all kinds of problems with it. So I hope you'll take that into consideration as this is laid over, but this is a non-starter.
Senator Westland.
Thank you, Mr. Chair. I think it's always important to read the language of the bill. It says that if the tenant does not control their own thermostat and it is provided by the landlord, it requires that they furnish heat at a minimum temperature of 68 degrees. 68 degrees is still pretty chilly. Nobody's getting sweated out, but if we have a 30-degree day outside and you do not have heat in your apartment, I'll guarantee you it'll be well below 68 degrees. And all this is saying is is during that time frame, it is incumbent on the landlord to maintain a minimum heat of 68 degrees. That's not sweating anybody out, but it is making sure that people have adequate heat. There is also the proviso in this that says, unless a utility company requires and instructs the heat to be reduced. So we're not asking that the heat be kept at 74 degrees. It's 68 is pretty cold in my world. But I think this is good, and I thank you for looking out for tenants.
Senator Holmstrom.
Thank you, Mr. Chair. I want to clarify something, and it seems like there's a lack of understanding of how this technology works. These HVAC systems, they don't blow out or radiate out at 68 degrees. They radiate out, they're either on or they're off. And what Senator Western was explaining is that it's not just flipping a switch. You can't just turn these on and off in the matter of seconds. There's a buildup and there's a cool down. And when it's 55 degrees at night and 80 degrees during the day, it's not that easy just to turn it off and on. It's either on or it's off, and it's putting out heat or it's not putting out heat. It doesn't put it out at any specific degree. So I think that that point went over some heads, but Senator Westron's point is fair.
Any further discussion? Senator Westrom, I couldn't tell if you were raising your hand to speak or not. You done? I've said my piece, I think. All right. You think, therefore you are. Any further discussion before we lay this bill over? Senate File 4104 is laid over for possible inclusion. Members, I think we can finish up our last bill here, Senate File 3565. Senator Clark. Members, this is also the first stop for this bill. The intention is to lay it over for possible inclusion. We do have some testifiers, pro and con, about the bill. There is an amendment, an A2 amendment, that is being distributed with the bill. Senator Clark, is that an author's amendment?
Chair Latz, yes, this is an author's amendment.
All right, Senator Clark moves adoption of the A2 amendment as an author's amendment to Senate File 3565. All those in favor say aye. Opposed? Motion prevails. The amendment is adopted. Senator Clark, tell us about your bill.
Thank you, Chair Latz, and thank you, committee. Members, I bring you Senate File 3565, a bill giving prospective tenants the right to view the dwelling for which they will rent. Straightforward bill. It requires that landlords notify prospective tenants of their right to view or tour the actual unit that they be renting before a lease is signed. The viewing of the tour can be conducted either remotely via an electronic method like your phone upon the tenant's request. This right could not be waived, and the landlord would be subject to penalties for a violation of this statute. And the author's amendment changed the initial penalties for the violation to be aligned with prior discussions that we have had to bring it in line with what we previously discussed. Passing this bill should place only a minimal requirement or burden on landlords. Really, the only thing a landlord would need to do upon the enactment of this bill and becoming valid, it would be to notify the prospective tenant of the right to view the actual unit. If the tenant does opt to see the actual unit, the landlord will need to provide a showing of that unit, but that shouldn't be an issue. Landlords are allowed to enter a unit to do a showing even if another tenant is living in that unit. The state's tenant privacy law expressly allows a landlord to enter a unit for this purpose. So I think this example that I'll provide should be a bit helpful. If you go in to buy a used car, you don't test drive a similar vehicle, you test drive the vehicle that you buy. And so that's what we're doing here as well. We want the buyer to have the opportunity to identify any issues with the unit prior to renting that unit. Tenants should be able to make a fully informed decision about where they will live by seeing the actual place that they will be living in. Without this law, tenants may be forced to make a decision based on rental housing based on the unit they won't actually be living in. And that is my bill, Chair Latz.
We have some testifiers signed up in favor. Is it Maya Grimm? Come on forward, please. And we have one remote testifier as well. So we'll start with Maya Grimm. Go ahead and introduce yourself, please.
Good afternoon, Mr. Chair and members of the committee. My name is Maya Grimm. I'm a housing attorney at Homeline, a statewide tenant advocacy organization here in Minnesota. Thank you to the committee and for Senator Clark for allowing me to testify today in support of Senate File 3565. As Senator Clark said, this is a pretty simple bill. It would give prospective tenants the right to view the actual unit that they'd be living in before they sign a lease and enter into that binding contract. We believe it's immensely important for tenants to know exactly what they're getting themselves into when they're looking to rent and to have the opportunity to make a fully informed decision before they decide where they're going to live. And similar to Senator Clark's analogy, when someone goes to buy a home, they tour the actual property that is for sale. Home buyers don't look at a neighboring property with a similar floor plan when deciding to buy. They look at the actual property that they'd be purchasing. So the buyer is fully aware of any issues that exist in the property before they make that decision. And unfortunately, this is just very often not the case when it comes to renting. So Senate File 3565 aims to address that. Oftentimes, prospective tenants are given the opportunity to tour a model unit or a similar unit rather than the exact one that they would be renting. Some landlords even keep model units, sometimes they're even staged, that are used exclusively for showings, meaning that no one has actually lived in that unit or at least has lived in it recently. These model units are kept in ideal condition and don't show any of the ordinary wear and tear that naturally occurs when someone has been living in that unit for some time. Tenants will tour a model unit or a similar unit and it looks okay, but then when they see their own unit for the first time, it may be damaged or dirty in a way that the tenant or the unit they toured was not. Homeline has heard from multiple tenants in these situations who are frustrated because if they had seen the unit that they signed the lease for as opposed to the one they toured, they would have never signed that lease. And this has actually happened to me personally, where I was shown a staged model unit and then later shown pictures of the actual unit that I'd be renting, and they were in vastly different conditions, not even necessarily related to repairs or cleaning, but even the appliances were much older than the staged unit I saw. And this practice keeps tenants from making a fully informed decision about their housing because they aren't given the opportunity to see exactly where they would be living. And as a matter of fairness, tenants should not have to sign a lease, a binding contract for a property that they have not had the opportunity to see. And this is why we support Senate File 3565. If this bill passes, landlords would only be required to notify prospective tenants of their right to view the actual unit. They can do this in person or also via a virtual remote tour if the tenant requests it. And ultimately, the tenant can choose whether they want to exercise that right. This law, like I said, poses only a very minimal requirement on landlords. They just need to make tenants aware of this right. And for tenants, this bill would ensure that they are able to make fully informed decisions about their housing. So we strongly urge your support for Senate File 3565. Thank you for your time, and I'd be happy to answer any questions.
Ms. Grimm, wouldn't it also impose a duty on the landlord that if the tenant chooses to exercise that right, that the landlord provide access to the proposed unit of rental?
Yes, if the tenant opts to do a showing of the unit that they would be renting, then the landlord would then have to conduct a showing or a viewing of that unit.
All right, thank you. Any other questions of Ms. Grimm? Senator Limmer. Okay. We're going to hear now from Bailey Morning, a tenant who is testifying remotely. Is Bailey Morning available?
I am. Hello, everyone. Can you hear me? Okay.
Yes, please go ahead. Thank you. Welcome to the committee.
Thank you. Good afternoon. This past February, I had the extreme displeasure of signing a rental agreement for a unit owned by a company called Cushman and Wakefield. Upon visiting the property, I was shown multiple different units. Some units were updated with stainless steel appliances, vaulted ceilings, etc., while some units were very outdated and looked as if they had not been updated for at least 10 plus years. After leaving, the property manager and I exchanged multiple emails back and forth about how I specifically wanted the updated unit that was shown to me. I was very adamant about this and even stated I would not be interested in the older units. The property manager explained this would be no problem as the unit was currently empty. I signed a lease and thought I was set for a seamless move in a few weeks. You can then imagine my surprise when I walked into an apartment with black mold in both showers, peeling paint throughout, foul odors, scratched and broken cupboards, stained floors and countertops. The unit was not even cleaned prior to move-in, so there were remnants of food scattered on the counters, in the cupboards, and the refrigerator. Lastly, none of the appliances were stainless steel or matched, which was now the least of my concern, the only item I mentioned wanting initially. At first, I figured the property manager had made a huge mistake or that this was kind of sick prank. However, when I rushed to the office, she confirmed my purchase paper, the lease that I signed, was the unit that I was talking to.
Ms. Morning, we're having difficulty understanding you. Sounds like the wireless connection is not strong. Are you able to refresh that? Or turn off your picture, maybe you'll get a better transmission.
Can you hear me better now?
Unfortunately, no.
That's could you hear any of the testimony?
Oh, yeah, now you're coming through clear. Yeah, we could hear.
Okay.
Yeah, go ahead.
Thank you. I'm sorry about that. Words cannot even express the pain, stress, horror, and personal hell I lived in for close to a month after this. The property managers stated they would be willing to move me into the original unit I requested at an additional cost. But that was the only quote-unquote remedy they offered. Luckily, I was able to find a way out of the lease and contacted the Better Business Bureau to file a complaint. I also contacted the property manager's boss at Cushman and Wakefield. This person issued me a full refund and sincere apology on behalf of the company, but it was too late. The damage was done. Because of this, I almost ended up homeless. I had no money to afford another deposit and more fees for a different unit. I had to beg my current landlord to grant me more time to find another suitable location. I had to go look again for more places, which took yet more time away from work. But the mental pain, the shame and embarrassment, the helplessness, not knowing if you will have a roof over your head every day for close to a month is something I would never wish upon my worst enemy. How can this happen? How can something seemingly be so straightforward end up so backwards? Moving is stressful. Usually there is also a time constraint. These property management companies take advantage of people and families in these situations because they can. Because nobody is telling them they can't. So please, I am begging you, tell them they can't. Not just for me, but for society as a whole. Think about the serious repercussions that exist solely because of this one issue that could be easily fixed. It should have never been broken in the first place. Thank you.
Thank you, Ms. Morning. Any questions from members of the committee for Ms. Morning, the testifier? I'm not seeing any at this time. Thank you for your testimony today.
Thank you again.
We have one testifier signed up opposed, Cecil Smith from the Minnesota Multi-Housing Association. Mr. Smith.
Mr. Chair, members of the committee, again, Cecil Smith with the Minnesota Multi-Housing Association. I'm here today to respectfully raise MHA's opposition to Senate File 3565. Ensuring prospective renters have a meaningful opportunity to view the unit they may lease is a reasonable goal, and almost all housing providers already offer this to meet market expectations. It is standard to offer in-person showings when feasible, provide photos, or even offer virtual tours of vacant units. These approaches help prospective residents make informed decisions and reduce misunderstandings. However, we have concerns with how the bill is structured. First, the requirement to provide remote or electronic viewing raises privacy considerations for current residents. Many units being shown are still occupied, and filming or live streaming inside someone's home, particularly if requested on short notice, may unintentionally capture personal belongings, documents, or other sensitive information. Even with good intentions, this creates concerns for current residents and may conflict with expectations of quiet enjoyment and privacy. Protecting the privacy of existing residents should remain a priority. Second, under current law, we are obligated to provide a 24-hour written notice prior to entering a tenant space, meaning there will be additional time restrictions for mandating viewing of a unit. This would only further complicate an already lengthy and sometimes stressful relocation experience for new residents. We would encourage a more balanced approach that supports transparency for prospective residents while preserving flexibility and protecting the privacy of current residents. We stand ready to work with the author on alternative language that reflects common practices already used across the industry. Thank you for your attention.
Mr. Smith, isn't there a way to include in leases that in the last 6 weeks of the term of a lease, if it has not been renewed, that the tenant, upon reasonable notice, has to make their unit available for tours by prospective tenants, either virtual or in person. Then they have no expectation of privacy in that 6-week window as long as proper notice is given.
That is true. Our concern remains with audiovisual recording in that space.
But if they're given proper notice, they can put away anything they don't want audio visually recorded, right?
That is true.
At least they'd be given the opportunity. It's up to them whether they wish to do so.
Yes.
All right. Any questions for Mr. Smith at this time? Senator Westland.
Well, Mr. Smith, I mean, how would somebody providing electronic access be less intrusive than having somebody do an actual walkthrough of the apartment? Not understanding why that's any more of an intrusion on privacy than actually having someone tour the unit. And I'm just going to say, too, this seems like such a small thing, especially given the testimony that we've heard. I'm surprised that every time a bill comes up, you are opposed to it. And it seems to me like this would be one that you could agree to.
Mr. Smith.
Mr. Chair, Senator Westland, we're opposed to the bill. We're not opposed to the practice. This is standard practice to provide a showing to residents. The audio-visual recording is concerning because documents can be captured and then reviewed later in live streaming. That's different from walking through an apartment where you're making your observations, you're getting an impression, and if residents have private information, photographs of children on the wall, and there's a recording of that, I believe that residents and myself personally would have concerns about people recording in my own home.
Senator Westland.
Well, Mr. Chair, and then Mr. Smith, if I walk through there, I might want to take pictures of the apartment to show somebody. You have no control over somebody doing that. So the same privacy concerns would exist with a walkthrough. And again, if I'm a tenant, I want to see the apartment I'm going to rent. I don't want to see a facsimile of it. And all this is saying is that if a tenant wants to see the actual unit, that they have a right to do that. And I am just struggling to understand why that is so objectionable, and I don't find the arguments you're making compelling. So I do support this bill. I think tenants have to have some rights and recourse. They're going to be spending a whole lot of money on rent. They should get the thing that they think they're renting.
Any further questions from Mr. Smith at this time? Senator Westrom. Senator Westrom.
Mr. Chair, Mr. Smith, the language in the bill talks about tenants, the right cannot be waived. I'm maybe a little concerned about that because it seems like even in an application process or in a lease, if a owner would have a statement that says they've offered it to him, I'm not sure that would be enough language to say, to counter that language that says it can't be waived, because if the tenant says, they never offered it to me before I moved in, how would you waive that? Do you have any idea? Or how would you ever prove that you had offered it to him if the tenant could always say, they never offered it to me?
Mr. Smith.
Mr. Chair, Senator Westrom, again, as with any new regulations where we prescribe a practice, we're going to have to document this. So we're going to have documentation now that the offer was made to the resident, they declined the offer to review the apartment, which is going to happen in circumstances where we have people who are in other countries or other states who are renting an apartment based upon what they see on the website or pictures that have been transmitted to them of the unit, and they're not able to see the unit before they rent it. But we'll have to document that process now based upon, if this was to become law, we'd have to document the process.
Senator West.
And Mr. Chair, Mr. Smith, I hear your position on it, and I just share some of your concerns. I think there's just some practical problems. I think the idea that most everybody's offered the space to look at is generally common sense if people want to, but there's reasons people don't want to, especially if they're out of town, out of state, kind of like an Airbnb. A lot of times they go off of pictures, and those pictures are similar or accurately represent the property. Most of the time, that's all works out. But Senator Clark, are you open to working on some of these concerns if this bill would move forward? What is your hope? I think there's a base premise that works here, but trouble damages, if you could get, the litigation could all come down to who offered what. They could fight about the owner documented that they said they offered it, but they really didn't, and then you can litigate that, and then the attorney fees would be subject to the owner having to pay it, trouble damages. What about just a common sense provision that just says if the tenant wants to see it, they can request it, period, and it's in the law. The option is always there. But I just think this language as it's written has a lot of unintended consequences, or a lot more problems with it than maybe intended. So what are your thoughts, Senator Clark?
Senator Clark.
Something we could work on?
Chair Latz, Senator Westrom, I always enjoy working with Cecil Smith. So yeah, and I'm being a little flippant there, but yes, we will continue to work. Regarding trouble damage, that was struck in my author's amendment, so that has been removed. And that was part of our prior discussion on another tenant bill that I had, where we got to a better general agreement on removing trouble and removing reasonable attorney's fees. So that part has also been removed from the original bill. So in the A2 amendment, it removed trouble and deleted and reasonable attorney fees.
Senator Clark, when my kids moved to New York, before they got there, they looked up apartments online, and they weren't able to get there themselves, and they didn't ask for, I guess, or were offered a remote tour, but they had a friend go take a look at the unit for them. And there doesn't seem to be any provision in this bill here to allow a prospective tenant or someone designated on their behalf to tour. Is that something that seems to make sense within what you're attempting to accomplish here?
Chair Latson, committee,
Senator Clark.
the intent in this is to allow someone, or I think allow them to understand what they are getting into. And so, and seeing it specifically, that specific unit. I think having a trusted partner would be a good spot that we could examine and figure out some good language to the designee of the prospective tenant would be something that we could continue to work on, especially since the path of this is to lay this bill over.
Any further discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. Senator Clark, I certainly agree with the spirit of your provision. The concern I have is on lines starting on 111, going on to 12 and 13, where we, the state, is telling a tenant that if they waive their inspection right, it's contrary to public policy and void. When I read that, I could only think of the word nanny state. Because quite honestly, are we ever going to allow buyers and sellers to negotiate their own future in a contract? If you give a buyer the right to examine a property that they want to rent, and they take the risk of not viewing it, maybe I should be so blunt to say, why should the state care? We're at a point that we seem to want to protect everyone on everything, and it will get unpractical. There may be an emergency where a person doesn't have access to a computer, is far away distant. Perhaps, let's say, a foreign exchange student in another country wants to rent a unit on a college campus in the United States, just doesn't have the equipment to look at something in a picture form. I think Senator Latz's idea of having a trusted friend to look at the property is a great idea. But to dictate the actions of a tenant, I think just goes a little too far. I'm a little troubled by that. Basically saying it's against the law to refuse to look at the property you're going to rent. I just think that we're a step too far on that.
Senator Clark.
Chair Latz, Senator Limmer, I take that as warm advice. What I'm attempting to do here is that we know that people who are, you're 20 years old, you're entering into your first time lease. This is something you don't do often. The apartment owner does this with great regularity. So this is where trying to make it just a little bit easier for that 20-year-old kid to be able to have a bit more in this. So I think open to continued conversations to find the right balance. But this is here's where we are at this time.
Yeah, and Mr. Chair.
Senator Limmer.
Don't get me wrong. I've walked through a lot of college campus apartments with my own children, and some of them are horrendous. And I remember back in my college days, you'd open the door, you'd get a whiff, you'd look inside the view of the apartment, and you wouldn't even want to take a step in. And if you did, you'd want to take a shower right away. And quite honestly, some of them are horrendous. And you're going in the right direction. I just think that one provision is just a step too far. I'm uncomfortable as a state telling a tenant that they cannot waive a risk that they're willing to take.
So, Senator Clark, the way I read that provision is not that the tenant can decline to exercise their right, but that basically it protects against a landlord forcing a prospective tenant to waive their right to look at a unit as a matter of law, as a condition of being considered for renting the unit.
Mr. Chair, maybe we should write it that way then.
Fair enough. Senator Clark's getting a lot of guidance here, and the testifier is getting a lot of guidance on how to work on the language of the bill. Any further suggestions on the bill before we lay it over and adjourn for today? Senator Holmstrom.
Just to speak really quickly about what Senator Limmer brought up. When I read the bill, that my confusion with it was what exactly triggers a tenant's right to recover. So maybe we can get some clarity on that as it comes back. Is it the plan to lay it over and bring it back, or is this going to go in an omnibus? Okay, thank you.
Well, it will come back as part of an omnibus package, presumably, yes, but then everything in the package is open for the committee to discuss and amend.
Thank you.
Any further discussion? All right, members, thank you for your good work today. We are going to adjourn in a moment. Just a reminder, our next meeting is Friday, April 10th, 9:30 a.m. in the Minnesota Senate Building, room 1200. Thank you. We are adjourned.